Nicholson on behalf of the state of Ohio. Mr. Dean, your attorney filed a motion for intervention in lieu of conviction, so in a moment you'll be asked to change your plea to the one count of the indictment. The court accepts your plea but does not make a finding of guilt. Instead, I'll hold your plea in abeyance or set it aside and require you to complete a plan of intervention. If you complete that plan of intervention, then the prosecution of this case will end with no finding of guilt, and I will dismiss this charge against you. Do you understand that?
Yes, sir.
However, if you fail to complete the plan of intervention, if you don't follow through with the court's orders, you use illegal drugs, or you otherwise break the law, then I will be able to make a finding of guilty that's based on your plea today, and then I'm going to sentence you on this felony. Do you understand that?
Yes.
How old are you?
I'm 24.
How far did you go in school?
11th grade.
Can you read and write?
Yes.
Are you a citizen of the United States?
Yes, sir.
Has anyone promised you how the court would sentence you in this case?
Yes, sir.
Has anyone threatened you in any way to get you to plead guilty against your will?
Yes, sir.
Are you satisfied with the representation you've received from Mr. Swift?
Yes, sir.
Are you currently under the influence of any drugs or alcohol?
Yes, sir.
Do you take medication that interferes with your ability to understand what's going on today?
Yes, sir.
I have in front of me a document called a change of plea. On the second page, on the line marked defendant, there is a signature. Did you sign this?
Yes, sir.
Did you read it and go over it with Mr. Swift?
Yes, sir.
And you believe you understand what it says?
Yes.
This document says you're running a plea of guilty to one count of theft of a motor vehicle as a felony of the fourth degree. That carries a maximum penalty of 18 months in prison and a maximum fine of $5,000. The prison term is not mandatory. Do you understand the maximum penalties?
Yes, sir.
You're also subject to a discretionary period of post-release control, which means that if you're sent to prison upon your release, the adult parole authority may supervise you for up to 2 years. If you violate those rules of supervision, you can be returned to prison for up to 1/2 of this court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer, and that time would run consecutive to any additional prison time you get sentenced to. Do you understand that?
Yes, sir.
It's not mandatory that you're sent to prison at all, even if you fail to complete ILC. The court still has discretion to place you into community control, or what some refer to as probation. While on community control, you'll have rules you must follow. If you fail to follow those rules, the court has the authority to extend the term of your community control or to impose additional, more severe sanctions, which can include local jail time or prison. Do you understand that?
Yes, sir.
You are presumed innocent of this charge. You cannot be sentenced or punished unless you plead guilty or you're found guilty following a trial. Do you understand that?
Yes, sir.
You have the right to trial by jury if you want. We will impanel a jury of 12 people and require the prosecutor to present sufficient evidence to convince each of the jurors of your guilt beyond a reasonable doubt, or the jury is required to find you not guilty, and their verdict must be unanimous. Do you understand that?
Yes, sir.
You have a right to require the state to present sufficient evidence to convince each of those jurors beyond a reasonable doubt. I've lost my place. I've lost my entire train of thought. Mr. Newberger, would you please sit? Gosh. Ben, I've done this 1,000 times.
It's usually like a machine. It just
I know,
rolls,
and
it just rolls.
I got so much going on. I wish I got so much going on over here. I got a jury waiting on me, and I'm just like, need to just collect myself here for a minute. All right, now at this trial, you have a right to see and hear all the evidence that the state has against you, and with the help of Mr. Swift, the right to confront and cross-examine each of their witnesses. Do you understand that?
Yes, sir.
You have the right to call witnesses on your behalf and in your defense. If any of those witnesses are reluctant to come, the court can force them to come by way of subpoena. That's your right of compulsory process. Do you understand that?
Yes, sir.
You also have the right to remain silent at your trial. You cannot be forced to testify against yourself. The prosecutor is not permitted to call you as a witness. You can choose not to testify in your own defense. If you don't testify, that will not be used against you, and I will instruct the jury that they are not permitted to infer your guilt nor anything from your silence. Do you understand that?
Yes, sir.
You have a right. I am just like lost this morning. I'm just lost. All right, so the burden of proof is on the state at your trial. You're not required to call any witnesses nor present any defense, and if you do not, that will not be held against you. Do you understand that?
Yes, sir.
And the standard of proof is beyond a reasonable doubt. That standard applies to each of the essential elements of each charge from the indictment. Do you understand that?
Yes, sir.
You could also waive your right to a jury trial, but maintain all the other rights we've discussed. You could try your case to the court. I too would have to be convinced of your guilt beyond a reasonable doubt, or would be required to find you not guilty. Do you understand that?
Yes, sir.
Do you believe you understand each of these rights we've discussed?
Yes, sir.
And you understand that when you enter a plea of guilty, you'll be waiving all these rights. We will not have a trial.
Yes, sir.
This is how you want to proceed.
Yes, sir.
All right, Ms. Nichols.
Your Honor, if this would have proceeded to trial, the state would have proven beyond a reasonable doubt that in September of 2024, the defendant spoke with the victim, Michael Paff, and was interested in purchasing his vehicle. He took the vehicle, never made payment for that vehicle, and that occurred in Mason, Warren County, Ohio.
Mr. Swift, anything on those facts?
Nothing.
Mr. Deaton, did you hear the statement that she read?
Yes.
Do you admit and acknowledge that what she said is true?
Yes.
And again, you understand all the rights you're giving up entering a plea of guilty, the rights we discussed?
Yes.
What is your plea?
Guilty.
The court will make a finding that you've made a knowing, intelligent, and voluntary waiver of your constitutional rights that we've discussed. The court will accept your plea of guilty. I am going to grant your motion for intervention in lieu of conviction and order these proceedings stayed pending the completion of the terms of that supervision. So you'll be at ILC for up to 3 years and subject to the supervision of the Warren County Probation Department. You're ordered to refrain from use of any drugs or alcohol, and this includes marijuana or THC in any form. You're ordered to complete residential treatment. After that, you're going to be placed in sober living and placed on electronically monitored house arrest. You're ordered to complete a theft class. You're ordered to pay restitution in the sum of $800 to Michael Pfaff. You're to have no contact with Mr. Pfaff. You're ordered to get your GED, and you're ordered to get full-time verifiable employment. You have 3 days jail time credit. Ms. Nicholson, did I leave anything out?
No, Your Honor.
Mr. Swift?
Well, Your Honor, he did complete the life skills class. He had a request that he's serving another sentence. He's been in for 104 days. I think that sentence concludes on Christmas Eve. He'd request for the record the court to release him at that time so he can be with his family.
He is serving his sentence with the Warren County Court case. His projected out date is 12/27/2025, and then the recommendation is to go to the PhD program.
All right, I'm going to follow the recommendation, Mr. Deaton. You got some substance use disorder issues that we need to deal with, and I'm not going to take a chance that you're going to relapse between now and the time I get you into treatment. All right, that's all. Mr. Madden? This is case number 24CR42159, the state of Ohio versus Lakita Miller. Ms. Miller is before the court with her counsel, Mr. Madden. Mr. Harris, on behalf of the state of Ohio, we're here for sentencing. Everyone's reviewed the pre-sentence investigation. Mr. Harris, anything on behalf of the state?
Yes, Your Honor. Ms. Miller has 0 days of jail time credit. We're requesting a restitution of $29,868.25. That is to the Mason cheer boosters. It's my understanding that is on deposit with the clerk's office, and that was part of the negotiated plea. Your Honor, based on the principles and purposes of sentencing, the factors including punishment, protecting of the public from future crime, rehabilitation, we believe that a period of incarceration is in order with followed with some period of supervision. The defendant put herself in a position of trust with the school organization to gain access to money for her own personal gain. Basin football boosters uncovered this. There were 9 unauthorized transactions. They were able to be backed out, but that put the cheer boosters on notice as the defendant was in a position of trust with them as their treasurer and had been for several years. They were only able to go back a couple of years, so this is what we came up with as restitution, which could be proven. And due to poor record keeping, which the defendant was in charge of, that was the reason why there wasn't really a clear picture of the total loss to the cheer boosters. The court has received numerous letters from Mason parents, PTO, different organizations, which Ms. Miller had contact with, describing the hardship that this has caused for them and their students. And defendant presents herself as well-educated, a successful professional. However, I was very shocked at her record, which includes convictions for theft, petty theft, misuse of credit cards, passing bad checks, identity fraud, probation violation, failure to appear. And also, again, shocked that this defendant has been to prison before in 2009. So this was not a one-time indiscretion. The state would ask for a period of incarceration that you be placed on supervision. After a period of that incarceration with restitution in the amount which has been agreed upon, corrective thinking as well as and/or a theft class, we would ask that she have no contact with Mason football boosters or cheer boosters. And we would also ask that she not be in a position of trust with any school organization or any organization for that matter while she is under a period of supervision. Your Honor, as you're aware, there have been numerous letters that have been sent to the court as well as myself. I know that there was going to be some representatives here today. I think due to the weather, they were unable to be here. We do have at least one member from the current treasurer of Mason Cheer Boosters is here. She provided a letter to the court as well. I don't think she's good with that. But this did have a major impact on the Mason schools. And as I said, this was not a one-time indiscretion. We do definitely believe that punishment is in order.
Anything from probation?
Nothing further. Your
Mr. Madden?
Thank you, Your Honor. The extent that this woman has changed her life in the last 9 months is really quite astounding. She lost a job because she had a great job, and she's obtained an even better job. I think she's making good money in a position of trust. In fact, they trust her so much they intend to send her to San Francisco this month, which she's been putting off because she didn't know the results that was going to happen here today. In the last 9 months, she has participated in therapy with Shirla Morris, who has recently diagnosed her with generalized anxiety disorder and disorder with disturbance of conduct, which could explain the situation she's gotten herself into at this point. She has 3 children. She has a loving husband. Mom and dad are here today. They'd like to address you. I'm hopeful that you put her on straight probation. I realize that she's learned her lesson. She knows what's going on, the change that she's made voluntarily. I didn't tell her to get into therapy. She did that on her own. And she's been going there 1 time a week and doing very, very well with that. I know she's remorseful. I read the PSI. It was a wonderful PSI. I truly feel that she believes what she said in there, and she is upset about what happened and what she did. I'd also point out that there's been no loss of money at this point that I can tell. She's repaid over $29,000 in funds. She has such positive momentum at this point, Your Honor. I'd like to see that continue. And I know you're busy saying there's a lot going on, but I know her father and her husband would like to speak to you. If you
Okay, that's fine.
Not have to speak into it, just state your name before the recording first.
My name's Anthony.
Oh, you can speak to me, sir.
I'm sorry. My
Yeah,
name
she's a probation officer. Not that she's not important, but you can address me.
sorry, yeah. My name's Anthony W. Hobbs Sr., and I am Laquita Hobbs, Laquita Miller's father. Thank you for giving me a moment to speak. I hope you had an opportunity to read the letter from my wife, Linda, and myself. As a father, I just felt the need to speak from my heart today. Your Honor, we raised our daughter Laquita in the church, surrounded by faith, family, and people who poured into her life. As a teenager, she was always serving, helping at church events, working with the youth.
Excuse me, sir. Mr. Newberger, I'm going to have to ask you to please just stop for a moment so I can focus on this gentleman. I can hear you. The court reporter can hear you. The internet can hear you. I need you to stop for a moment,
Thank you, Your Honor.
please,
My
so that I can
apologies.
focus on this gentleman. Okay,
Thank you.
I'm sorry, sir.
As a teenager, Laquita was always serving, helping at church events, working with the youth, and doing whatever was asked of her. That caring and giving spirit, that is the daughter that my wife and I know. But I also understand the seriousness of what happened. We are not standing here trying to excuse anything. My heart truly goes out to the individuals who suffered loss because of her actions. Her family felt that deeply. That's why we didn't hesitate to refinance our home. We wanted to do whatever we could to help make things right. Over these past months, I have seen a change in my daughter. I've seen tears, I've seen remorse, I've seen her wrestle with the pain she has caused. She has been trying hard to face this, to grow and to become better. She wants to be the mother her children really need, and she wants to return to the values she was raised with. Your Honor, I'm asking from a father's heart, please show mercy. I truly believe there's still so much good in her. And I know she can turn her life around if she is given the chance. Thank you, Your Honor, for listening to me today and for considering my wife and our request.
Thank you, sir.
So you're just stay next to the light, say your name for the court reporter.
Sean Miller. Me and Laquita got married in 2010, and we moved here. We moved to Mason in August of 2010. Since we moved here, our children have been involved in almost all community aspects, from cheer. Started off in dance, cheer, and my son started off in football. When we got here, the first incident we had was Laquita was stressed. I was at work. She was a stay-at-home mom. I work at the Air Force Base up in Tepe. So I would commute every day up to work, and there was a charge on her report about her child endangerment. Well, she was stressed that day. When her daughter was asleep, so she left the two in the car with the van to run in and get diapers and come back. When she came back, she was surrounded. People wouldn't let her leave. Oh, you're all right, cool. So since then, we've been more involved in the community. At one point in time, Laquita was the PTO, president of 3 PTOs, 2 elementary schools and middle school. During which time she raised the most money in Mason school history, $80,000. So after she did that, she helped to create a program at the Mason Middle School for, it was a student union association. And then she created another student union association at the high school to help kids go on college business. This is not the behavior of someone who's a criminal or a thief. So this helped me, her receiving her diagnosis, helped me clear up and come to an understanding that when she is stressed, she doesn't respond. She hadn't responded appropriately. It was like, she's super intelligent, has an MBA, graduated second in her class in high school, graduated college with a 4.0. So when she gets stressed, the diagnosis, when she gets stressed, she doesn't make the best decision. I needed to hear that from the doctor because it cleared up so much for me as to how her things impacted over time. Again, I just wanted to get up here and tell you as a husband, this year has been so hard on our family. And to watch her go through it and transform, she's lost over 50 pounds. She lost a job. She never quit being mom. She showed up for the kids. As a family, we are truly remorseful for this. You know, our daughters were on the cheer team. One daughter graduated last year. My other daughter was on the cheer team, and she had to endure this too. So I just ask that you guys can find it in your hearts to show mercy. She has atoned. She has made changes, and I want you to hear it from me and know it from me. That is what happened. We are truly and sincerely sorry, and we look forward to being able to contribute and give back to the community.
All right, thank you, Mr. Rowland.
And I just point out one other thing, Your Honor, if I may. I've handled dozens and dozens of theft cases in my career. And the one thing that always seems to be clear to me, it's usually not a malicious situation. There's usually something underlying the theft case that causes it to happen. And I think that what we nailed it here with Ms. Morris's prognosis about the situation, diagnosis about the situation, that this is what has happened and it's fixable. And the fact that she's been seeing this woman for 9 months, made some changes, some very positive changes. This is not a malicious situation. It always happens. There's something underneath this thing that makes people steal.
Ms. Miller, you have the final word before, well, actually, I have the final word, but anything you'd like to say before I sentence you?
I have prepared a statement, if I might. Your Honor, thank you for allowing me the opportunity to speak today. Standing here is one of the hardest moments of my life because I know that I alone am responsible for the choices that brought me here. I want to begin by expressing my sincere remorse. What I did was wrong. I violated the trust of people who believed in me, and I violated the values I was raised to uphold. There's no justification for it, and I accept full responsibility. My actions reflected poor judgment, and I regret them every day. The consequences of my behavior have been real and far-reaching. The Mason Touchdown Club and the Mason Cheer Boosters deserved better from me. The parents, volunteers, and community members deserve better. And above all, my husband, my children, and my parents deserve better. My family has paid a painful price for my mistakes. Because this case has been public, the scrutiny and harsh judgment, especially toward my children, has been devastating. They did nothing wrong, yet they've carried emotional and social burdens because of my actions. Witnessing their hurt has been the most painful consequence of all, and it forced me to confront how deeply my poor decisions have affected the people I love the most. Your Honor, I want to provide honest insight into what led to this offense, not to excuse it, but to explain the psychological state that I failed to manage in a healthy way. At the time, I was under intense emotional strain, financial instability, and untreated mental health challenges that I did not recognize. I was overwhelmed, anxious, and operating from a place of fear and self-doubt. And instead of seeking the help I needed, I tried to carry everything alone and made impulsive decisions while under significant emotional distress. These choices were mine, and I take responsibility for them. Through therapy, I now understand that the symptoms I was experiencing align with adjustment disorder, with disturbance of conduct, and anxiety disorder, stress-related conditions that have impaired judgment over various periods of my life, resulting in overwhelming pressure and life changes. This doesn't mean or lessen my accountability in any way, but it's helped me understand why my thinking became distorted and why I reacted in ways that were unhealthy and out of line with the person I strive to be. Most importantly, it's given me a foundation for meaningful long-term change. Since January, I've been in consistent therapy and have worked hard to address the underlying issues that contributed to this behavior. I've learned concrete tools to manage stress, anxiety, shame, and fear in healthier and productive ways. I've gained better insight into my emotional patterns and have developed more effective coping and communication skills. I know I'm fully responsible for what I did, and I'm committed to ensuring that nothing like this ever happens again. I understand the seriousness of this offense. I understand the harm I caused and the trust I violated. This experience has changed me profoundly. I stand before you not asking for sympathy, but for the opportunity to continue demonstrating through consistent actions that I'm committed to rehabilitation, accountability, and responsible living. I hope the court will have mercy and recognize that the progress I've made over the past year is real and ongoing, and allow me to continue on this path for my rehabilitation and the well-being of my family. Again, I'm deeply remorseful. I'm committed to being a better person, wife, mother, daughter, and member of this community. And I promise that nothing like this will ever happen again. Thank you for your time.
Thank you. Court's considered the statements made here today. I've reviewed the pre-sentence investigation. I've reviewed the letters submitted on behalf of the victims in this case and on behalf of the defendant, the purposes and principles of sentencing, the relevant seriousness and recidivism factors. I will tell you, Ms. Miller, it is very hard for the court to reconcile, in my mind, the person portrayed by your father and your husband, which I believe 100%, with the person that I'm looking at here that whose history of thefts goes back over 20 years. 20 years ago, you started this path of stealing from other people. Have you ever had something stolen from you?
Yes, sir.
Not a very nice feeling, is it?
No.
Stealing from strangers is one thing. Stealing from people who have placed their trust in you is completely something different. I personally have been involved and have run youth sports organizations. I was the president of the Lebanon Youth Football League for 8 years before I took the bench. I will tell you, we had an incident before I became president of someone stealing about $80,000 from our organization. And I was able, because I was an attorney, I was able to get all the money back. We did not pursue criminal charges, but so I know how they feel. And it's not a good feeling. I'm really struggling with reconciling this in my mind, to be honest with you, because the person that's standing before me, a highly educated, present yourself very well. You come from a good, solid background. Your mom and dad are both here in the courtroom supporting you. It's hard to reconcile this person with the person that stole this money. And again, I'm taking into consideration that you've made restitution, at least as far as they could prove. Now we can probably speculate that there was probably more taken than what you actually was paid back, but having to take that into consideration. Well, but this is difficult for me to reconcile. The person that's standing there, I don't know. The recommendation from the pre-sentence investigator is I send you to prison. That's the recommendation. You got that? They think I should just send you to prison. I'm sure that the people from the Mason Boosters and the cheer club, they probably want you to go to prison too. I'm just guessing. I mean, I don't know that they actually came out and said that, but they want you to be punished. So I'm trying to balance all this in my mind. I'm going to give you one last opportunity. Who's the real Lakita Miller? You see where my dilemma is?
Yes, Your Honor, I do. What I've learned over the last year is there have been patterns over the course of my life that have resulted in these instances. The record that they spoke about earlier was over 15 years ago. I went a long time without having an issue, but what I've identified in therapy were things that I did not address in my youth and my childhood that maybe had I known then, I could have taken steps to mitigate things like this from happening. Not making an excuse, but at least I know now what the diagnosis is, and I can continue to work towards not repeating the behaviors that resulted in me making these horrible decisions. I think the person standing before you today is the one that I feel most authentic than I felt in a very long time. I hate what I did. There were people who respected me, who I had made friendships with, that I've lost because of my decisions. And they're right to feel how they feel. They absolutely are. I don't want to take away from that at all. But I'm not the same person who did this. I'm not the same person. I was a very immature child, away from home, away from my family, making impulsive decisions when those thefts and passing bad checks occurred. And so there was a long stretch of time where I thought I had a handle on things. But there were things in my mental health that I did not identify and therefore had gone unaddressed. And I think those contributed to this horrible series of choices that I made in the last year.
All right. Ms. Miller, at this time, the court is going to make a finding that you are amenable to community control. So I'm going to place you into community control for a period of 3 years. You'll be subject to the supervision of the Warren County Probation Department. You're ordered to refrain from the use of any drugs, alcohol, or marijuana. I don't allow marijuana. I am going to order you to continue to successful completion your mental health counseling. I'm ordering you to complete the Thinking for a Change course. You're to have no role. You are forbidden to have any role in any organization. You understand that?
Yes.
No role of authority in any organization while you're on supervision. You're not to handle money other than your own. You understand that?
Yes, Your Honor.
My understanding is the restitution has been paid and deposited with the court. Now, the court does find that you have the financial ability to pay the cost of prosecution. So while I'm not going to fine you, I am assessing against you the cost. If you don't pay those, I can't order you to do community service of up to 40 hours per month until you pay that in full, or you make appropriate arrangements to pay that. I am also ordering you to serve 90 days in the Warren County Jail. You have 0 days jail time credit as of today. I'm going to allow you to schedule that with probation. I will give you work release while you are serving time in the jail, and however you arrange that with your probation officer is fine with me. But you're going to serve some time for this, so you're going to be spending the nights. I'll let you make arrangements for your family, your kids to be cared for during that time. But there has to be some element of punishment to this as well. I'm not sending you to prison today. But you will serve 90 days in the Warren County Jail with work release. You're also subject to a discretionary period of post-release control, which means if you ultimately are sent to prison on these charges upon your release, the adult parole authority may supervise you for up to 2 years. If you violate that supervision, you can be returned to prison for up to 1/2 of this court's original sentence by the adult parole authority. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer, and that time would run consecutive to any additional prison time that you get sentenced to. Mr. Harris, is there anything else?
Your Honor, requesting a no contact order with the cheer and football boosters of Mason.
Well, again, I'm not sure how these organizations, are your kids involved in those organizations at all any longer?
No, Your Honor.
Yeah, that's fine. I don't know why she would have contact with them. What do you mean contact?
Just that I know that was involved in the community with these.
I just
individuals.
ordered-
I don't think they want any more contact with her at this time.
Do you have children in the age of those organizations?
Our youngest daughter is a student at Mason High School, but she's no longer on the cheer team. So
Because of this?
no, she decided on her own that she didn't want to participate.
All right, no contact with those organizations. Anything else, Mr. Harris?
No, Your Honor.
Mr. Madden?
As far as implementation of this, Your Honor, can we do this after the holidays?
She's gonna arrange it with probation. I've given her that leeway, so I mean, I'll let her talk with the probation officer and arrange that. Anything else?
Okay.
All right, best of luck to you, Mr. Madden.
You want to give the appellate?
Oh, I'm sorry. You have a right to appeal the court's decision thank you. It's a bad morning. You have a right to appeal the court's decision of your sentence to the 12th District Court of Appeals. If you want to appeal my decision, you must file your notice of appeal within 30 days of today's date. If you can't afford to pay for the transcript or anything necessary for your appeal, that can all be provided to you at no cost. If you cannot afford an attorney, I will appoint one for you at no cost. Anything else, Mr. Matt?
Thank you.
All right, thank you. Good luck to you, man.
For driving without a valid license. That's very common. We get lots of those. It's a misdemeanor. It's punishable by up to 90 days in jail and a fine of up to $100. We sometimes refer to it as no ops. This was at 10 o'clock at night on 131 and Michigan Avenue, right there.
It was morning time, sir.
Morning, 10 in the morning, okay. Let's take a look at your driving record. You don't have one. Did you ever have an Indiana license?
Well, my license was suspended because I didn't turn in a SR-22 form. I turned in the SR-22 form a week after I found out my license was suspended.
What's a SR-22?
I have to hold insurance for my car for 180 days.
It's an Indiana device. Yeah, so where are you in the process of getting your license back in Indiana?
I already have my license back.
Oh, you have it back? Do you have it with you?
Yes, I do.
So I don't think there's a question whether he had a license.
picture license at the time, just whether or not it's valid or not.
Yes, we'll show it to that gentleman over there. He's the city attorney for Three Rivers.
Get proof of insurance.
It is so very valuable to have the city attorneys here. We've kind of lost our county prosecutors again. But for the sake of the people that are coming in for the arraignments, it's very helpful to have a prosecutor here.
Your Honor, reduces to the civil infraction on impeding traffic.
All right, that's quite a generous offer, Mr. Young.
And for the record, what he showed me is consistent with what he said, a valid form of insurance, valid as of November 20th. So within a week of the citation, he did obtain insurance.
Yeah, they ran this driving record on the 19th. So the next day he got it valid. So Mr. Young, you did everything you were supposed to do. So good for you. You just did it a day late. Impeding traffic is a civil infraction, doesn't carry any points, and it carries $100 fine. Are you willing to plead to that?
Mm-hmm.
All right, the fine for that is $100. A bunch of pens here that don't work. Can you pay that today or do you need time to pay it?
Can I pay it Thursday or Friday?
Well, I'll give you till the end of the month. I'll give you to December 31st.
Okay.
End of the year. I'll give you this. You can pay it with a credit card. You can mail in a certified check or money order. Or you can bring in green cash, but you're good to go. All right, good luck, sir. Cole Kindig? He's here somewhere, but he's not in here.
Yeah, he's out on the bench out here. Just gonna affect
drugs. You're not to purchase, possess, or consume any one of those. You're to submit to chemical testing, PBTs and ETGs. Kratom poppy seeds and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. I want you to submit to chemical testing, PBTs and ETGs as follows. Weekly for 4 months if you're clean, bi-weekly for 4 if you're clean, then monthly, okay? And after, I'll cover that in a second. I want you to attend AANA at least 3 times a week. We're going to hand you a form. You have to go in person. You can do it in Ohio. Every time you go, you have to have the form signed. And I want you to do that 3 times a week until you're in intensive outpatient treatment. I'm ordering intensive outpatient treatment. And once you get in the intensive outpatient treatment, you no longer have to attend AA or NA. I want to make sure you fully understand that. Do you?
Yes.
I want you to also understand I'm going to order that you attend the Victims Impact Panel. Okay? Attend the Victims Impact Panel. That is one night. That is put on by Mothers Against Drunk Drivers. Do we have some weight out down there? I'm going to order also, I'm going to go kind of light with you. I mean, you got some serious things going on here, but I'm going to give you a chance. You got a good record. I'm going to go 6 days jail, credit 1, serve 5. And I'll have you serve those by way of community service. Okay, so 5 days of community service, I'm going to give you all the way until, let's see. Let's see, December, January. I'll give you until February the 15th of 26 to complete that, okay? So that's in lieu of jail, no jail time, 5 days community service by, again, February 15, 26. If you comply with all these terms and conditions, and I'm going to fine you that I'm including that, then I want you to understand that your probation could be revoked. You could be incarcerated for a year on count 1. You could be incarcerated for 93 days on count 2. The fines on these cases are going to be as follows, and any fines that I'm attributing to that are common, I'll put on count 1. $100 in fines. This is on count 1. 100 fines, 200 costs, 75 victims' rights fee, $50 justice assessment, 4.25. Probation fees are $360 for 785. Your screening fee is $60 for 845. Again, you could get 365 days if you violate. On the other file, I'm simply going to go $100 fines, 200 costs, 75 victims' rights fee, $50 justice assessment. That's on the impaired. I recognize you're paying on count 1 some of those fees. So this is only going to be, I have to go at least 300 costs. So I'll go 5.25 on that case. Or 93 days, credit 1, serve 5 by way of community service. You have 21 days to appeal. You have 14 days to apply for a court-appointed lawyer for purposes of appeal. I'm going light on you with the fines. You're only going to pay $13.70. That's a gift. You're to obtain and maintain employment and provide proof. Now, I'm going to give you prosecutorial review date. You do have to appear in person for that. Every time you go, you have to have the form signed. Every time you come to court, you have to bring the form with you, okay? So that's what I'm going to do. And Lisa will give me a date, and it's going to be sometime in the neighborhood of about July of 27, right? Or June of 27, May of 27.
Well, I was going to do May.
That's fine.
That's what I had.
No, that's fine.
May 4th at 9 o'clock.
May 4th of 27 at 9 a.m. Now, you may be eligible for early discharge. You get everything done, and as long as the prosecutor doesn't have a problem with moving to dismiss on the 7411, I'm not going to have a problem. You got to get your life in order, though, young man, okay? I expect full compliance here, all right? All right. Does he have all this to pay? How much do you have today, sir?
I'm in.
Yes.
I didn't bring nothing down there.
Okay.
Can I make a payment over the phone?
Yeah, you can pay with a credit card when you get home if you want. You can pay with a credit card now if you want.
How much would I have to pay?
You tell me. I'm not gonna lock you up, but
I could pay like 200 now.
okay, you pay 200 now. How much can you pay weekly or bi-weekly? You get paid weekly, right?
Bi-weekly.
Okay. When do you get paid next?
Just got paid, so 2 weeks. So next Friday.
Okay, so that would be on the 12th, the 15th, 29th. You don't have any kids or a wife, but still, we're gonna let you start paying on January the 9th. Well, I'll make it January the 12th. How much can you pay bi-weekly beginning January the 12th?
To be honest, I'll have it paid in full by then.
All right, well, I'm gonna offer you the opportunity to pay $200 bi-weekly beginning then, and then you can pay bi-weekly 200 on count 2 after fines costs paid on count 1, okay? You're going to meet with your probation officer today. So, and by the way, again, I think I alluded to this, but you should leave the state without consent of the court, okay? Mr. Kinney, anything else?
Thank you.
Always a pleasure. I wish it was later in the day. We could go out and reminisce. Thank you.
Thank you.
Take care. Good luck, sir.
Thank you.
All right. Susan Melindy Jewett. 25S57127 and B.
Good morning, Judge and staff. John Graziani, P number 43387, on behalf of Susan Short.
Good morning, ma'am. How are you?
What's your name?
Susan Short.
Good morning. All right, so for purposes of arraignment, does she stand mute and waive formal reading?
Yes, she does, Judge.
And now she's going, you did a great job. Your lawyer did a great job on this. She's
Always so kind, Judge McNally.
you're going to plead to impeding traffic. They're going to dismiss the improper lane use and no license, okay? You all right with that? You understand what I said, ma'am?
Yeah.
So you're going to plead to impeding traffic, which is 0 points. It won't go on your record. I am going to fine you. And they're going to dismiss the misdemeanor charge of no ops and the 2-point civil infraction that you have. Do you understand that?
They're dismissing those two other charges and you're pleading to impeding. You understand it, yes? Okay, she does, Judge.
Okay. To the charge of impeding traffic, responsible or not responsible?
Okay.
Responsible? Say yes.
Responsible.
Okay, perfect. I'm accepting that plea. Dismissing the no ops and dismissing the improper lane use on motion of the prosecutor, and I'm fining you $160, okay? All right? Do you understand? Does she have that?
She has the money, Judge.
Good luck. Have a nice Christmas. Have a good day. Thank you. All right. Demaria Jamel Andrews, 25M588, 995A, B, and C. Where is, the defendant's not here?
The trooper's on Zoom. I have not seen a defendant.
Okay, so we can bring in Trooper Byer. Ms. Andrews, Demaria Andrews. Good morning, Trooper Byer. How are you? Your name?
Hey, good morning, Your Honor. Yes, sir. Trooper Byer, Michigan State Police.
All right. So I'm going to call one last time to Demaria Andrews. Demaria Andrews here. All right. Defendant failed to appear. You know, and it's funny because looks like this was set. The default judgment was set aside and then she didn't show up today, but that's her fault, not mine. So I'm going to go ahead and enter default judgments on all of these. Lisa, they've posted a bond of $585. I'm presuming, can you look at that and tell me if that will cover all the fines that are outstanding on this? If I have to waive a couple fees, I'll do that just to get rid of it.
Yeah, let me add up her balance. Her balance is 585.
Perfect. Default judgment is entered, applied bond to payment of fines and costs. I'm not going to write that on every one of these, okay? I put it on the B file, but apply those bonds, default is entered, and we're all set. Trooper, do you have any more, sir?
No, Your Honor, just the one today.
Have a great day. If I don't see you, have a nice Christmas. Thank you.
Thank you, sir. You as well.
Ethan Anthony Marvin Steigerwald, 25M61862A, and this is Trooper Samsel. Mr. Calvin, you're going to be next. Your name, sir?
Ethan.
All right. Is the trooper out there? It says the officer is here. Samsel, Sampsel. Good. There he is. Good morning, Trooper. Trooper Samsel, you can start your video and state your name, please. Good morning.
Good morning. Trooper Samsel with the Michigan State Police.
All right. Holding or using a mobile device What happened to the B file, Lisa? Did he pay that or something, or did that get dismissed?
Yeah, it was a voiding ticket.
Okay, so you took care of the window tint,
Yes.
you had it signed off on and it was dismissed, is that right, Lisa?
Correct.
Okay, sir, Trooper, is there an offer here that you care to extend? It looks like he's got a good record. He doesn't look like he's had any tickets.
Is this for Depew or Stingerwald?
This is for Stegerwald.
Stingerwald. Oh,
What were you doing?
pull up here. Had the wrong ticket up.
That's okay. The use of mobile device.
If
Awkward.
I may, Your Honor, I'll be honest with you, I was at a red light, picked up my phone for 2 seconds, put it right back down. I've been in the hiring process with Customs and Border Protection. So.
With Customs and Border Protection?
Yes, sir. I actually did get the job fine.
Working with who?
Homeland Security downtown.
Congratulations. Good for you.
So it was poor timing on my behalf.
Use your brains though, okay?
No, I
got it. Can you offer him impeding, Trooper?
Yep, absolutely.
I mean, I don't care if he got a job with Homeland Security or McDonald's. I think it's warranted in this case. You all right with that?
Yes, sir.
To the charge impeding traffic, responsible or not responsible?
Responsibly, Your Honor.
Good luck to you.
Thank you so much.
I wish you well. I'm still going to charge you 185 though. Go down the hall and take care of that. Best of luck.
Yes, sir. Thank you.
All right, come back when you're running the FBI or something. Do you have another one, Trooper?
So I had one scheduled for Gavin Ray Depew, if I'm saying that last name correctly. Same thing, cell phone and window tint.
Do I have that? Lisa, did that defendant take care of this? I don't have that file here.
He's not on Zoom. I'm not sure if he checked in person.
Who is it? I don't have the file.
The last name is Depew, Depue, set for
Okay,
915.
So we still have that on, the docket then. Give me 1 second. We're going to pull that up. I don't know where my court officer is, but I'll have him get it when he comes back. Kaplan Trucking Company, 25S 118271.
Good morning, Your Honor. Dan Calabit appearing on behalf of Kaplan Trucking Company. Your Honor, there is 2 Kaplan Trucking Company files, 2 different overweights.
Yeah, I also have 25S 118268. Can you see if you got a Depew file down there, John, that was scheduled for 9:15? You're setting it for formal?
Yes, Your Honor.
Lisa, can we do the 26th at 8:30?
Yeah, yes.
That would work. I appreciate that.
Oh, wait, Judge, that's a Friday. Did you say the 26th?
No, the 16th I meant. Maybe I said the 26th. I meant 16th.
Oh, I'm sorry. Okay, the 16th at 8:30?
Yeah, Your Honor, I have 2 other hearings that morning. Can it be like into early January, or is that too far?
I don't want to go that far. Why? You guys couldn't resolve that one? This one?
Well, this is a situation where my client says there was a street close. They couldn't avoid it. So we wanted to talk to the trooper. And unless we can do a Zoom, just initially, maybe can we try like a Zoom formal? I'm not going to push to conduct it. I just want to talk to the trooper.
I don't understand. What do you want me to do? Just set it for formal or set it for something else?
Can it be a Zoom formal or no?
Well, I can't conduct a formal on Zoom. Okay. I mean, I'll set it later in the morning if you want. If that'll help you, I can set it for 11 on the 16th.
That would be perfect. Thank you.
Okay, I'll set it for the 16th at 11. That's okay, right, Lisa?
Yeah, that's fine.
I appreciate it. Thank you, Your Honor.
So we'll set it for the 16th at 11 a.m. But it seems like you guys, this isn't one that's subject to the masking rules, right? I mean,
no, they'll reduce it, but the issue is like if my client was actually overweight, there was a road that was closed.
All right, I don't need to hear it. That's okay. Yeah. You're entitled to that. That's not a problem. We'll set these for the 16th at 11 o'clock. Okay.
I appreciate it. Thank you, Your Honor. Have a great day.
Have a good day. Thanks.
Thank you. Bye-bye.
Did you see the Depew, DEPUE? It's supposed to be scheduled for 9:15.
I didn't see that one through. The only 9:15 one that I had was.
Did you say he's?
For trooper sample. I didn't have a Depew.
Lisa, did I misunderstand you? Did you tell me that Depew was out there?
No, Depew did not check in with me. He's a no-show. So we just got to put the file up.
We don't have the file John's telling me down here.
All right, I'll look around.
Trooper, just give me, I'm sorry, just give us a few minutes, will you please?
Yes, sir. No rush.
Oregon Oil Company, 25S118269. Good morning.
Good morning, Your Honor.
Your name?
David DeVries,
What is your position with Corrigan?
Head of Corporate Security and Safety. Your Honor.
Okay, so I don't want to be painful about this. This is the way it is.
I understand, Your Honor.
Do you?
I do. I'm a retired state trooper.
I can't let a safety person or a manager, I'll let, when there's no contested hearing and the principal, the president or the vice president shows, I'll be glad to let them tender a plea if that's what this is. I'm not trying to give anybody a hard time, but I got rules I got to follow. So I can, if you want, I can schedule it for the 9th. I'll let one of them appear by Zoom.
Can I have my attorney, corporate attorney?
Yeah, that'd be best. Can you call him now? Have him enter an appearance or not?
I can call Brad right now. Yes, sir.
Why don't you see if he can appear by Zoom and he could file an appearance and I'll take the plea today.
Okay.
Okay?
No problem. I apologize, Your Honor.
There's nothing to apologize about.
I represent him. I just found this out. I've been representing for 8 years and on civil infractions, and I just found out that they know the terms now. So for the corporation.
Well, I can tell you on ours, I've always required that unless you got the president. If you had the president, I'm okay with it. I'm not trying to make money for lawyers. I'm just.
Oh, no problem, Your Honor. I thank you though for being with us on this.
No problem. Whatever you want to do, just make their calls and let me know. I can adjourn it if you want. Okay? Thanks. To Tatiana Monet Richardson. It's 24B703477. Good morning, Ms. Grady. How are you?
I'm very well. Good morning, Judge, to you and your staff. On behalf of.
Where is Ms. Richardson? I have to get her in here. Okay, Ms. Richardson, your name, ma'am?
Tatiana Richardson.
And Ms. Grady?
Yes, Your Honor.
I need your appearance, though. I don't think you said it. Maybe you did. If you did, I missed it.
I'm Judith Brady on behalf of Tatiana Richardson, P44567. Ms. Richardson already stated your name, did you?
Yes.
Judge.
You want an adjournment for a week, right?
Yes, sir.
Ma'am, Ms. Richardson, your lawyer needs more time to prepare. You have the right to a probable cause conference within 14 days. She needs to review the discovery. She's asking me for an adjournment for 1 week. If that means that means I'll do that if you choose to waive your right to have the probable cause conference within 14 days, in which case I'm going to set the PCC for next week, and I'm going to set the preliminary exam for the 16th. Do you understand what I'm saying?
Yes.
Do you waive that right?
Well, I'm sorry. You're asking me to waive the probable cause?
No. I'm just asking you to, if you want to, you can waive your right to have the probable cause conference within 14 days of the date of the arraignment. I will set it next week. And then I will set the preliminary exam the week after. Your lawyer needs more time to prepare. That's what this stip says. Adjourn 1 week to review discovery. So do you wish to waive your right to have the probable cause conference within 14 days, knowing that I'll set it for next week?
Okay, so I understand that you're saying we'll still have the preliminary exam. And
I'm not asking you to waive anything at all other than your right to have the probable cause conference within 14 days. That's all.
That's fine. Yes.
Okay. I'll accept that waiver. We'll set it for December 9th, Lisa, that's the PCC at what time?
9:15.
At 9:15. Preliminary exam will be at what time on the 16th?
10:30.
On the 9th, is that on Zoom?
You can be on Zoom next week and then in person for the preliminary exam at 10:30 on the 16th, okay?
correct. So thank you, Judge.
No problem. We'll see.
Judge,
What?
can I ask if you have a case on your docket? They're asking me if you have a Janelle Bruce today. And that's,
Yes. Yes,
you
we
have-
do.
is there an attorney on that?
No, I have several cases that are awaiting assignment. That's one of
Oh,
them.
I see. I just wanted to check to make sure that's what they're asking. Okay. Well, thank you very much, you and your staff, Judge.
Have a good day. Thank you.
too. Thank you.
Thank you.
What do you want to do?
Insurance, so he can.
Yeah. Oregon Oil Company, 25S118269. Yeah, come on back up here. Your name again?
David DeBreeze, Your Honor.
Is it DEVRIES?
Correct.
And you are the safety manager?
Safety and security, yes, sir.
Safety and security manager. All right, we'll adjourn it a week. And I'll set it for the 9th. And we could do this at 8:30, have the lawyer enter an appearance. He's gonna have to still Zoom with the prosecutor, okay?
That's fine, Your Honor.
Have a great day.
Thank you.
Thank you very much. Take care of yourself.
Have a Merry Christmas. Your
You too. Thank you. All right. There isn't a Mr. Depew in here, is there? Depew?
He paid.
Oh, he paid. Trooper. I'm sorry. That's why I don't have the file. He paid. You scared him. He knew you were gonna provide excellent testimony. Have a good day. Merry Christmas. Thank you.
You, sir. Thank you, guys.
I'm gonna ask you what all you people are here for. Sir, what's your name?
Richard Labate.
I'm sorry?
Richard Labate, Your Honor.
Labate. What are you here on?
Traffic violation.
What time?
38.
Okay.
The officer's here on that one, Judge.
Okay. Do you have Labate down there? How about you in the orange back there, ma'am? What? Okay. What's your name? Tucker. Are they pulling that file or have they?
The officer has Labat and Butner, if you want to put both of those up.
I don't see any files down here.
They're in plastic folders.
Yeah, I know. They're. What's your name, ma'am?
Tucker.
I don't have any of those. All the plastic files that I have have already been taken care of. I have Steyerwald, Kaplan, and Andrews down here. I'm sending you down one where I got a doctor's note, Lisa, and I'm gonna have you cancel that warrant and reschedule. I'd rather not mention that on record, but that's. How about you guys? What are you here for? What time's that scheduled? 8:30? Stanley is the last name. What's your first name? I'm sorry?
That's assigned to Mr. Graziani.
Oh, I see. And how about you? Are you with Mr. Stanley, sir? Okay. So we're looking for a civil infraction file called Labate. And another.
And Butner.
Yep. I have them right here. They were scheduled for 9:30, so. Put them up right here.
Okay, perfect. How did I miss those over there? I don't know where you looked.
Oh, I was back in the jail with them, so.
No, how did I miss them?
Oh. Did you find the other one?
We need Tucker walk in and we need Labate. Labate is a civil infraction.
Find a pew.
No.
He paid.
Oh, he paid
He
it.
paid
Oh,
it.
yeah. Good morning, Trooper.
Good morning, Your Honor. How are you?
Good, thanks. Let me ask you to.
Yes,
remove
I do
attitude.
apologize.
That's
Bad
all
hair
right.
day. I apologize.
We're. I have those a lot.
I can't see it. I can't see it.
From 2275.
We're still looking for your file. We don't have Labate down there, do we, Jim?
Is that Labate?
Yes, yeah. I don't know. I missed it. I went down.
No pew, all right.
I just have Labate. Yeah, Labate and Buechner, I guess.
Okay.
Okay, people against Richard Scott Labate, 25M618478. Come on up to the podium, sir.
Good morning.
Good morning to you. Your name?
Richard Scott Labate.
All right, so Mr. Labate is here. Trooper, your name?
Daniel McLaughlin, Your Honor.
He's got a clean record. Any offer here?
I already gave him a substantial reduction to 1 to 5 limited access, right on the roadside. So we went from 88 to 1 to 5.
Right. So you can plead to that or you can have a hearing. If you plead to that, it's 0 points. It's gonna.
I was only gonna ask, Your Honor, that.
I know. Everybody wants no points. I don't control that. You know what I mean? He's saying he gave you a break from 88 to 75. So with 0 points, it will go on your record for sure. You can take a driver improvement course. The Secretary of State will send you a letter if you want to do that, and it would remain off your record, at least to insurance companies, but I can't do anything more.
I'll just leave him at it.
All right, to the charge of 75 and a 70, responsible or not responsible? All right, I'm going to accept your plea. 135 is your total. You can go down the hall and pay that. And like I said, you can take that course and keep it off your record. Law enforcement will still have it.
Check, do I do that for the Secretary of State?
Yeah, but they're going to send you a letter.
Okay.
You probably will get the letter in the next 2 weeks, and it's going to give you like 45 days or 60 days or something to complete that. Okay. All right. Wish you well. Merry Christmas. Scott James Buechner, 25M615477. Mr. Buechner, your name? You have to unmute, sir.
There you go. I'm sorry. Yes, I'm here, sir.
Your name?
Scott James Buechner.
All right, Trooper, your name?
Yep. Good morning, Your Honor. Daniel McLaughlin.
All right, so he's got a clean record. Same thing, though, 88 and a 70. Well, he had 1 and 21. So is your position good?
I gave him this. I gave him the same thing. I gave him 1 to 5 already. I gave him a break on the roadside.
So do you want to plead to 75 and a 70, sir, or do you want to go to the hearing? It's 0 points, but it will go on your record.
I'll take the driver improvement course and I'll
Well, I don't think you're going to be eligible for it anymore because I see one on your record from 21.
Is that 4 years ago?
I don't write these rules. I just do what they tell me. You know what I mean? That's if
Yeah. Oh, I understand. No, I'm not arguing. I just don't want any points.
Well, you won't have points. It's going to go on your record.
That's fine.
To the charge 75 and a 70, responsible or not responsible?
Responsible, Your Honor.
All right, 135 is your total. You can pay that today, right?
Yeah.
And you're all set. And now we'll go from there. Anything else you want to say, sir?
No, sir.
Trooper, anything else? You don't have any more, do you?
Downey, but from my understanding, she hasn't shown up. First of Courtney, last of Downey.
Do I have that one?
I'm looking, Judge.
You're all set, Mr. Butner. You can go right on 33court.com with your case number and make your payment, okay? 33court.
Court.
COURT.com.
Okay.
All right. Have a good day. Thank you. Merry Christmas.
You too, sir. Bye-bye.
Downey's not on the docket.
No.
Is Downey on the docket, Lisa?
How do you spell the last name?
Is it DOWNEY?
Correct. Yep. I got her here 12/2/25 at 9:30.
What's the first name?
Courtney, common spelling.
She paid it.
She paid it.
Yep.
You're all set. Merry Christmas if I don't see you. Take care. Thank you.
Absolutely. You as well. Merry Christmas to the 33rd. You guys have a wonderful rest of the
Thanks. You too. All right. Who else do I have here? Has anybody pulled that Tucker file yet, Lisa? She said she was walking. You checked in down there, right, ma'am? Good morning, Ms. Lynch.
Good morning. How are you today, Your Honor?
The walk-in
Great.
needs to go to jury assembly to see the attorney.
Okay, you need to go to jury assembly to see the attorney. You know where that is? Right out those doors and just continue to your left. That's the jury assembly room. All right. What defense lawyer is here on your case, Ms. Lynch?
Patillo.
Do you have Patillo down there? I mean, not Patillo.
Attorney.
What's the name of? I'm sorry.
It's Lawler, Marcus Lawler.
Marcus Lawler. I saw that over there, John. It might be over there.
Or I'm sorry, Marcellus Lawler.
Hello. Hello. I'm going to call your case in 1 second. Just give me a minute, okay? Okie dokie. All right. People against Marcellus Cortez Lawler, 25B725167. All right. Everybody's name, please.
Good morning, Your Honor. Dinah Lynch on behalf of the people, P84589.
And sir, your name?
Marcellus Lawler.
And Ms. Patillo, your appearance, please.
Good morning, Judge Dion Patillo, P82378 on behalf of Mr. Lawler.
Can you start your video, please?
Yes, Judge, I'm trying. Just give me one quick second.
Okay. On this case, are we going to proceed to the exam, Ms. Lynch?
Yes, Your Honor, we are. We have an exam date already scheduled for the 8th.
Right, on the 8th. Ms. Patillo, you can just unmute and tell me your name. I don't know. Okay, there you go. Your name?
Dion Patillo, P82378 on behalf of Mr. Lawler.
Good to see people smiling around here, Ms. Patillo. December 8th at 1 o'clock, we're going to exam, okay? We'll see everybody in here on that
Yes,
date.
sir.
We scheduled that last time. Sir, you have to be here in person. Don't be late, please, okay?
Okie dokie.
Have a good day, everybody. Thank you. See you next
Thank you, Your Honor. Have a good day. Bye-bye.
You too.
Bye-bye.
Thank you, Judge. Can I be put in with the other prosecutor, Esmaro?
I'm not sure what your question is. You kind of cut out. Or who do you want to be put in with?
I moved her to the prosecutor room.
Okay. Okay.
Okay. Thank you, Judge. Thank you.
No problem. And Mr. Graziani has this gentleman's file, right?
It's okay for me to hang up now?
Oh, yeah, you're all set.
Okay.
Sir,
Thank you.
I'm so sorry. What's your name again?
Stanley.
Yeah, you were scheduled for 8:30, and
He had Stanley, Banks, and Jewett.
okay, Mr. Graziani. Have you spoken to the lawyer yet, sir?
Yeah, I was waiting on being.
Oh, I see. Okay. Well, he's got a lot of cases, all right? So just please be patient. We'll be with you momentarily. Good morning.
Morning. How are you?
You're a new prosecutor.
I am
What's your name?
Natalia.
Natalia?
That's Nelia.
And what's your last name?
Asmaro. I used to come here with Mohammed. I think I've only done like 1 year.
I thought so. Yeah, how are you?
I'm
You
good.
passed the bar and everything. Was it just this time?
I passed it in February.
Congratulations.
So much. And,
So now you've been at it for 4 months and you're,
as an attorney, yes, it's the end of June.
yeah,
6 months.
yeah, okay, okay.
They put me out county, so I'm actually excited about that. And
Well,
so,
good. And you got Mr. Kaplan back there. You give Mr. Kaplan my best.
see you.
Yeah.
I'm excited to come see you.
Well, it's good to have you here. Congratulations to you.
I Ron, this district might be moving to, he's gonna move to Tuesday, so I might be here after the new year.
Hey, great. Romulus is moving to Tuesdays, huh?
Yeah, I don't know why. It's such a busy docket though, so maybe that has to do with it. I don't know. They need 2 days for the docket, honestly.
All right. Well, good to see you here. All right. Lisa, have we heard from the prosecutor's office as to what we're going to do?
On what? I'm sorry.
The week of Christmas. Am I still going to have it on the 20?
Yeah. We'll have the
Oh.
23rd and the 30th because we're open.
Okay, so I'm not here the 30th, so I took a day off, but all right.
Yeah, we'll just do PCCs that day.
Okay, Peter Latch, the 4th. 25F726113. Mr. Latch, start your video, please. State your name. Good morning.
Good morning. Peter Locke the fourth.
Good morning. Ms. Ford, good morning. Your name?
Good morning, Your Honor. Deborah Geraldine Bledsoe Ford on behalf of Peter Latch the fourth.
All right. Well, who? Not that it's going to help you or hurt you. Bledsoe Ford, your mom was a judge, right?
Yes.
Okay. You decided to go the other route, huh?
No, my mother was Geraldine Bledsoe Ford, that most people know it from Frank Murphy. But I actually succeeded her at 36th District Court for 18 years. And then on the bench, and then I had to retire 3 years ago. So now I'm resuming my private
What,
practice.
you turned 50 or something? You had to they make you retire at 50 now? All right. So you guys need an adjournment. Here's what I'll do. I got to get these out of here by the end of the year. So I'll give you your 2-week adjournment on the PCC, but we got to have the exam on the 23rd at latest. Okay.
Okay, and what I did talk to the prosecutor. I may file a motion. They know, or we may work something out. So we've got something going on.
All right. Is this going to include sobriety court or not?
I don't know. I'm trying to maybe look at a technical angle because I believe he has diabetes. So I'm not sure. I think it could have flawed the results. That's what I'm really saying.
Okay.
But they're also talking about an offer that I may really be interested in. So that's
I
where
don't
it
have a
is.
problem, but I just need you to understand. I'm going to do it. And
Yes, the answer to your question is yes. At the end of the day, if it comes to sobriety court, yes.
okay, sir, your lawyer's asking for an adjournment. She wants to talk to the prosecutor. If I grant that request, that means this probable cause conference will not take place within 14 days. She's asking me to move it for 2 weeks. I'll be glad to do that. But that means you'll be waiving your right to have your probable cause conference within 14 days of the date of the arraignment. Do you understand that?
Yes. I mean,
You
whatever.
waive that right?
Yes, it's
Yeah.
good for you.
Anybody force you to do that?
No.
Okay. So my state docket, Ms. Ward, ends on the end of the year. So I got to get all these cases out. So I'm going to give you the 16th. We can do at 8:30 in the morning. And the preliminary exam at what time on the 23rd, Lisa?
10:30.
At 10:30, but no more adjournments, okay?
Okay,
I'll
the exam is at 12:23 at 10:30, right?
Correct. You can appear by Zoom on the 16th at 8:30.
Thank you.
Have a good day. So
Bye-bye.
you retired and you went back. You couldn't leave at 52 or whatever it is that they, huh?
It's in my blood. It's in
I
my
know
blood.
what you mean. I know what you mean.
You know, my
It's a tough-
grandfather was a lawyer too, and I lived with him for a while. It's just there. And my
Yeah,
uncle was
so-
on the bench in Highland Park. And I also think you shrivel up when you stop.
I
know.
don't disagree. I don't
Yeah.
disagree. My father, lawyer, or my father, uncle, and grandfather were all lawyers, besides my son and two others that are cousins and my brother. So
Oh,
I get the point. Why do you think I'm still here? Lieutenant, your name?
Detective Lieutenant Chris Remba, City of Flint Rock Police Department.
Just wanted to acknowledge you there. We'll see you back here in a couple weeks,
Okay, can I
everybody. Have a
say
good
this?
day.
My daughter just passed a New York bar. So I'm trying to help her. I'll just leave it at that.
Why in the world is she going to work in New York or Detroit?
Well, she's taking the California bar now, and she's not
Oh,
working.
she's smart. She's going to go to the beautiful Sunset, but she's going to pay
I think she's
$2 million
not smart.
for a house, right?
She should be like your sons. Come back and grow on top of growth.
Disagree. I don't disagree. My father, lawyer, or my father, uncle, and grandfather were all lawyers, besides my son and two others that are cousins and my brother. So
Good morning. Are you Adrian Hayward Jr.? And Mr. Parker, will your client waive the formal reading of the indictment?
Yes, Your Honor.
Mr. Hayward, in cause number 24 DCCR 2149, you're charged with the third-degree felony offense of assault family violence by impeding breath or circulation from May 23rd of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you actually did what they charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 5-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Hayward is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. Mr. Nichols?
This is his first case that I'm showing, Your Honor. If he's going to be released on bond before sentencing, I'd ask, obviously, that no contact with victim, he stay away from that address, that he not be allowed to possess a firearm. While the allegation isn't for using a firearm, there's allegation in the reports that he had brandished one that evening.
Okay. What's your relationship with Rihanna McClain?
My girlfriend.
It was your what?
Ex-girlfriend.
Your ex-girlfriend's cousin. So there's no reason for you to be around her, or it sounds like your ex-girlfriend at all, or anybody like that, right? So here's what I'm going to do. Based on the nature of your plea agreement, I'm going to reduce your bond in your case to $1,000. Condition of that bond, if you make it, is that you are to have absolutely no contact or no communication in any way. That's obviously in person, but it's through social media or sending messages or anything with her. Do you understand? You can't go to an address where she is. If you're somewhere and she shows up, you have to leave. Do you understand? And then also, as a condition of your bond, you are not allowed to have any firearms at all. So if you own firearms, you need to get rid of them. If you have a family member that can take them, I don't care what you do with them, you can't have them or have them in your home or your car, okay? Any questions? All right, we'll see you back at sentencing.
Thank you.
Thank you. And then Jason Jones. Okay. Mr. Rojas, you have Jalen Hendricks sentencing.
Jalen Hendricks.
Hey, Sharon, he's on the other end.
That's sentencing. Good morning. How are you?
Good, how are you?
Good.
This is for my other one. You just gave me that this morning.
This is for which
Mr.
one?
Yeoman. Yeah, there's another question.
Okay.
You didn't switch from the slides. Just one little bit. Just a little. All right.
Morning, Mr. Coleman. Would you put that with Leonard Yeoman sentencing, please? I know. Like my nose is gonna start. Good morning. Are you Jalen Hendricks?
Yes, ma'am. Good morning.
And Mr. Hendricks, you were previously here in cause numbers 23 DCCR 2323 and 25 DCCR 0574. Entered pleas of guilty in each of those cases to evading arrest or detention with a motor vehicle. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
We have, Your Honor. State has judge.
Are there any additions or corrections?
Not from the judge. Not from the state judge.
Mr. Hendricks, do you have a driver's license?
No.
Okay, so I'll explain what I'm going to do in a second. So I'm going to find Mr. Hendricks in each of your cases that you entered your pleas of guilty freely and voluntarily. In cause number 23, DCCR 2323, I'm going to follow the agreement you made and sentence you in accordance with it to a term of 10 years in prison, but probate that. You'll be on probation for 10 years. You're ordered to pay a $500 fine and to serve 30 days in the county jail. You will get credit for that time since you've entered your plea. In cause number 25, DCCR 0574, also find that you entered your plea freely and voluntarily, find sufficient evidence to find you guilty, and at this time follow the agreement and find you guilty of evading arrest or detention with a motor vehicle. Sentence you in accordance with that agreement to a term of 10 years in prison, but probate that. You'll be on probation for 10 years. You're also ordered to pay a $500 fine to serve the 30 days in jail that you will get credit for, and follow all of the rules and conditions of probation. So the rules and conditions of probation are very important, because if you don't follow all of those rules, you're going to be right back in here looking at 10-year sentences. Do you understand? You've already agreed to 10 years. So part of your probation is going to be to get you the help that you need for whatever's going on. So you will be assessed for any type of mental health care, and you're ordered by me to follow any recommended treatment. That means medication, counseling, whatever it is. If they say you need it, I'm ordering you to do it. You understand? Also, you are not to drive any vehicle, period, ever, unless you have a driver's license. So you cannot drive. And then and all the other regular conditions of probation, and the probation officer will go over that with you. If you do everything that you're supposed to on this probation, it's a great opportunity because you'll be able to serve that 10-year sentence while you're on probation instead of in prison. But again, if you violate any of the conditions of probation, you will be right back in here and you'll be looking at that 10-year sentence in each of those cases. You understand? I'm handing you in each of your cases the trial court certifications. It shows that these were agreements that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. All right, good luck to you, sir. You can go back with the bailiff.
Thanks.
And then Lamone Yeoman, sentencing. Yeoman. Good morning, you're Lamone Yeoman Jr.
Good morning.
And Mr. Yeoman was previously in court on probation for aggravated assault with a deadly weapon and also burglary of a building, and pled true to allegations in the motion to revoke those probations to counts 1, 2, 4, and 5. Does the state have any evidence with regard to the others, or are you ready to go forward?
No, Your Honor, I'm just ready to go forward.
And I've received and reviewed the updated pre-sentence report. Has everyone had an
I
opportunity?
misspoke, Judge, on the, because I believe you pled true, not true to number 7, which is failing to report. I do want to address those.
Okay,
I'm sorry, I meant that on number 6, the new firearm case, nothing's been brought over, nothing's been filed, so I have no evidence to present on that.
okay. Let me get that pulled up. You may proceed.
Would you please?
I'm sorry, would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
It's Ms. Cole, right?
Yes.
And how long have you worked for probation?
A year.
And during your time of probation, have you supervised Lamone Yeoman Jr.?
Yes, sir.
And was he required to regularly report?
Yes, sir.
Were there times where he failed to regularly report?
He reported one time on April 7th, and we didn't see him again.
He reported on the 7th, you've not seen him since.
Until he was arrested, yes, sir.
So is it safe to say that on April 11th of 2025, April 21st of 2025, April 30th, 2025, May 9th, 2025, June 6th, 2025, and July 7th, 2025, he did not report as required to see you or to the probation?
That is correct.
Thank you. I'll pass witness.
Any questions?
I'm sorry, can you give me that date that he did report again?
April 7th.
April 7th. And have you were able to talk to him about different reasons why he didn't report?
I called him actually on his birthday, and I told him you have a warrant, and he told me because it was his birthday, he was not going to tell me.
Are you aware of any time while he's, since his removal from safety, are you aware of any times where you may have called him or sent him text messages about a data report that he didn't get those messages?
I called, I sent letters, and I called his mother, and his mother told me that he was aware of the warrant.
I'll pass the witness.
Another question for purposes of proving up count number 7, Your Honor.
Okay. Based, any witnesses or information about count number 7?
Okay.
All right, then based on that testimony, I am going to find sufficient evidence to find count 7 true. All right, and so Again, I've got the updated pre-sentence report as well as there was a letter provided this morning. Mr. Nichols, have you had an opportunity to review the letter? It's
I did not show it to Mr. Nichols.
and take a look at that. Have y'all both had an opportunity to review the pre-sentence report update?
We have, Your Honor.
Yes, Your Honor, I have.
Any additions or corrections to that report?
Just a correction to the page one, the bottom paragraph. It says that Mr. Yeoman was absconded from the aftercare program. He tells me he did not abscond. He was kicked out of that program.
Okay. I guess being kicked out is better than being absconded. Anyway, all right. Anything else?
That's what the PSI noted.
And it looks like there was cap of 8 years agreed in the aggravated assault case, and then just really open in that burglary of a building on the state jail to run concurrently, correct?
Yes, Your Honor.
Mr. Rojas, you may make argument.
Thank you, Judge. The court knows from reading the PSI, Mr. Yeoman was in safe P. He did successfully finish the first part of safe P. The aftercare program is a part that he was kicked out of. He pled not true to count one as far as, I believe that counts as he was selling K2. What Mr. Yeoman tells me is that one of the roommates in one of his roommates in the aftercare was selling K2. All the roommates in that particular room were kicked out because the person selling did not claim ownership of the K2. So everybody in that room was kicked out. And that really just started the downfall for him on the probation judge, because at that point he was released from safety in Houston. He had to find transportation back to Port Arthur. He tells me the phone that he had, the phone number that the probation department had originally, he did not have that phone anymore. So when the messages were given to him to report, he wasn't able to because he didn't know about those. When he finally did get back to Port Arthur, he had trouble finding transportation. And that's when the new offenses came up in August, and as far as the possession and the weapon charge. So according to, if his story is to be believed, that he was not selling K2 and everybody in the room got kicked out.
There's not much for you to argue here today. Sir. You haven't given your attorney anything to argue for you.
I don't want to say that it's not his fault, but really, if he truly was not selling the K2, he would still have been able to finish that safety program. And that's what he's asking to get the opportunity to do this morning, is finish that aftercare program, possibly even due to those new offenses, one of them being weapon, maybe even consider sending him to ISF Cognitive to help him make better decisions. And if you had more questions about what happened at safety, Mr. Yeoman is willing to talk about those.
So there was an ISF, okay, there have been 7 administrative hearings, 7. There have been, on the first case, the aggravated assault case, this is the 3rd motion to revoke probation. The first motion was filed literally, what appears to be a week or 2 after got on probation, given another opportunity. Then, did he go to ISF? I can't tell. Anyway, regardless. Then we get a new case of, while you're on probation for aggravated assault with a deadly weapon, you obviously aren't doing what you're supposed to. You get some jail sanction where you spend 5 weekends in jail. Then you decide to go commit another felony, a burglary of a building. You come back in here. We all agree somehow for you to stay on probation for the first felony, give you another probation for the second. And then we're here again. I sent you to Safe P. And not only did you get kicked out of Safe P, whether it was your fault or not, you also have been arrested now for 3 new offenses. Is that right? 3? 2. 2. Sorry, 2 new offenses. Mr. Nichols?
Judge, I'd urge the full extent of the cap that was agreed upon. Even without the problems in safety, the fact that he simply has not participated in his probation for the last several months or most of the last year, that he's been given multiple chances. And if you go back to his original PSI from 2019, from the 2019 offense, the Agasol, he downplays what he did. And he's never taken responsibility really for what he does. And I think the recommendations of the probation are correct in that he just refuses to grow up, refuses to take responsibility for his actions. So I think the 8 years is appropriate, Your Honor.
I think you're lucky that Mr. Rojas got you a cap of 8 years, honestly. Because what you're on probation for is a second-degree felony, the first one. And the opportunity after opportunity after opportunity that I've given you and probation have given you, at some point, we kind of start taking it personal that you're just saying, screw y'all, I don't have to do anything. She's gonna keep giving me probation. I'm gonna come in, I'm gonna write a nice note, take responsibility at the last minute. You've done none of that. You've done nothing that you're supposed to. You make me look like an idiot up here for giving you all of those chances. I'm going to find in cause number 19-32846 that you entered your pleas of true to counts 1, 2, 4, and 5 freely and voluntarily. Find those counts true. Also find count 7 true. Find sufficient evidence to find you guilty, and at this time find you guilty of which one is that? Aggravated assault with a deadly weapon. Sentence you to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 23, DCCR 1556, also find counts 1, 2, 4, 5, that you entered those pleas of true freely and voluntarily. Find those counts true. Find count 7 true. Find sufficient evidence to find you guilty, and at this time find you guilty of burglary of a building. Sentence you in accordance with your that agreement to a term of 2 years in the state jail prison. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In each of these cases, they'll run concurrently, which means together at the same time. I'm handing you the trial court certifications that shows that these were agreements that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of those judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. You can go back with the paper. Thank you. Thank you. This needs to be, I wrote notes on that. There's all of that. Goodness gracious. Mr. Who do I have? Mr. Matusko, you have Traylon Hill. My favorite. Good morning.
Good morning, Your Honor.
Yeah, I don't.
Yeah.
Just more. I'm not gonna, I'm done talking to him about it.
Your Honor, I did file something. Could you?
Which one?
Like Mr. Hill about this.
Let me see if it came through.
I received it, at
You
least
did?
by this morning, Your Honor.
Okay.
I'm not opposed.
Hold on a second. Good morning, you're Traylon Hill. Let's see, what is it?
It's a motion for continuance. By Mr. Matuska, Your Honor.
You just paid the bond before.
Nobody's talking to you right now, okay? Don't say, Mr. Hill, don't say a word unless someone asks you a question, okay? I don't see the motion is what I'm looking for. It may be one of the,
charges?
Cases.
All four. I just got a script error. Do I hit yes or no?
Yes, it's fine.
Sorry, now my computer's acting up.
Did you try it? Did you try it?
Huh? I haven't seen it yet. It's not even showing up, but now I've gotten to where I can't X out of anything, so. All right, so Mr. Hill's cases are set for trial to begin with jury selection next week. And Mr. Matuska, you filed a motion for continuance.
I did, Your Honor. At the last setting, Your Honor, the court informed me that this case was urgent. We did receive all the discovery. I printed out all of the written reports and provided a notebook to the jail. I've gone down there with the laptop. The guards at the jail have informed me that Mr. Hill is refusing to come out and meet with me, to go over his discovery with me.
Okay.
And I have not had an opportunity to show him based.
Don't talk, I'm gonna talk to you in a minute. Don't talk over people.
I'm not talking over him.
You're talking over me right now and you're talking over him. Mr. Matuska,
Based upon that information I'm receiving from the guards, I've also reached out to the family, Your Honor. They seem concerned for some other reasons.
I haven't been out to the cell,
that the court may be aware of. But I have made efforts to provide him the opportunity to see his discovery, but the jail is telling me he's refusing.
all right, so I'm going to grant the motion for continuance. I am also going to go ahead and order an evaluation be done. Mr. Hill, it's very important if Mr. Matuska or any doctor or anyone comes out to visit you, that you visit with them. It's going to help move your case along, okay? So it's,
I paid for Burbank. I don't even know who this is.
so Mr. Burbank has not been paid because he's not here to represent you. Mr. Matuska is your lawyer. I appointed Mr. Matuska, who is an excellent attorney, to represent you. Mr. Burbank got off of your case.
But the reason why is 'cause
listen.
I've been to court 14 times and I'm looking to go because I have no evidence on me.
Listen,
During this whole entire thing.
you and me both are ready
So
for
y'all
you to
invaded
go.
y'all invaded
Both
my
of us
community.
are ready. Go back with the bailiff.
Y'all invaded my
Listen, if they
community.
come out to visit
All my
with you, you need to visit with them.
constitutional
Go back with the bailiff.
Hey, watch where you hold me, sir. Don't touch me like that. They know I touch me. I know how to walk, sir. You don't get it at all.
Your Honor, after the evaluation, if there's maybe another way that we could order some kind of sitting where I can just give him the opportunity to see him.
Yeah, I can, what we can do after that's done and we get it, if we need to, we can have him, I'll contact the jail and see if we can either have him brought here with cards or you somewhere at the jail where I'll order that they force him to go. Okay. All right, I'm gonna let you fill out all that. You can have this. And I want whoever's appointed, make sure that they also get a copy of all of that so they know what's going on. Thanks. Mr. Kimler, let's see. He's here. Mr. Kimler, you have Colton Armstrong, a sentencing. Okay, I'm gonna have to X out of this whole thing. I might have to get signed back in now. It's.
I brought you a letter on him yesterday. Did you get your letter?
I got it.
Someone else's PSI on accident next door.
Oh, sorry. No, the other.
All right, are you Colton Armstrong?
Yes, ma'am.
And Mr. Armstrong was previously in court and cause number 25 DCCR 0002, entered a plea of guilty to theft of property enhanced to a third-degree felony. There was an agreement for a 10-year term to be probated for 10 years. There was not going to be a fine and $20,000 in restitution. Is that correct, that that was the agreement?
I thought it was, is it 10 over 10?
That's what I had, just 10
Okay,
over 10 with
that's
the 20,000 and rest.
Yeah. And then I received the pre-sentence report. Has everyone had an opportunity to review the report?
Yes, Your
I
Honor.
have.
What is the status of the Hardin County case?
Pending.
I have made multiple attempts to contact Mr. Hopper over there. No one. I'm sorry.
Okay.
I've spoken with him. He doesn't, at this stage, isn't offering probation. I think what I would do, once Mr. Armstrong is granted probation here, he would post a bond on that case and then just set it on the regular trial docket in Judge Thomas's court. And offers tend to change over the course of the pendency of the case. I think Mr. Hoffer's going to retire probably before the case will be reached for trial.
And Judge, our position.
I'm not
I know.
being flippant. It'll be assigned to someone else.
Yeah.
Our position on this was to make this offer obviously conditioned on the amount of restitution and his paying the restitution. As you can see, he pled to more than one paragraph, which elevated it to
Sure.
10 over 10. And we would, of course, be asking for the full 10 on the revocation.
Right. And y'all also, I guess, understand the recommendation that was made after the substance abuse assessment with regard to ISF cognitive and then JCDI after.
I would let Mr. Armstrong speak to that, Your Honor. I think and in counseling with him, he advises that he thinks he's at a point now where he has a new child, needs to be there for his family to support.
Well, based on the criminal history and the 2 different probations that have already been revoked, if I'm going to go along with the agreement, then I want him to have every tool to be successful. And that's what's going to happen. So it's not necessarily meant to be a punishment, but if that's what's recommended, then they're the professionals. And I want to give you all those tools so that you can be professional, be there for yourself, your kid, and everything else. So then anything else?
Cognitive track or something.
Cognitive track, and then JCDI as aftercare. So there, he gets both.
The problem there, Your Honor, is that he does have a pending case in Hardin County, so I don't know that he would be able to go.
Bill's gonna have to be, once I'm done, they'll transport him over there because there will be a hold here and he'll have to get that case taken care of before he goes one way or the other.
So if he were to post bond, I guess he would still be.
He won't have a bond. He won't be able to get out in this
That's what I'm
case
saying.
because he'll have an ISF hold.
Okay.
So, and if something happens and that case does not get resolved, file something, let me know. And depending on the time frame that he's sitting, I might reconsider, but I want to at least order that and then we'll go from there.
Since he's getting probation here, that may impact.
Right. If it doesn't impact it and it's going to get set on some docket that doesn't get taken care of for however, long, then just let me know. And then potentially I would hold it in abeyance, the ISF, if he has to go sit over there for a long time. Okay.
Would the court also consider imposing a trespass warning for all TNT record locations and the use of any and all of their services? I know they have multiple locations and businesses here in the area.
Just stay away from that.
All right, so here's what I'm going to do, Mr. Armstrong. I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, follow the agreement that you made with the district attorney. Find you guilty of theft of property enhanced to a 3rd degree. Sentence you to a term of 10 years in prison, but probate that. You'll be on probation for 10 years. There will not be a fine. You are ordered to pay $20,000 in restitution and to follow all of the rules and conditions of probation. Sorry. Does anybody else see that? There's a bug flying around. I feel like I look crazy. You're going to be ordered to go to the cognitive track of ISF and then through the JCDI program as aftercare, which is an outpatient treatment program. So you'll be transported over to Hardin County. If something gets worked out once you get there, then you'll go straight from there to ISF. If for some reason that doesn't get worked out and things are going slow, Mr. Kimler will get in touch with me and I'll will reconsider the ISF. I want you to go because I think it's good for you. I want you to start getting your GED. I'm going to order that as a condition of your probation, you are required to, once you're out, and there might even be the opportunity in ISF to start that. I'm not sure. But if not, once you're out, within 30 days of being out, I want you to start that program. Again, that's going to be helpful for you, for your children, to get better jobs. And so that is part of your probation. You are ordered to not be on the premises of or use the services of TNT Wrecker as a condition of your probation also. I'm going to hand you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Kimler. And I don't know, I'm kind of reconsidering. With the Hardin County stuff, I'm going to do this. Listen, hang on, listen. This is what I'm going to do, just because I know that could take a while over there. I'm going to hold the ISF. I'm going to hold ISF in abeyance, which means you don't have to go to ISF. So you will be able to make bond. You will be ordered to immediately start the JCDI program, but you're going to have to change your behavior on your own without that 90-day program. Here's what we're not going to do. If I give you this opportunity and you do get a probation over there and you're getting out and you start making bad decisions again, you're old enough to be making better decisions. The argument doesn't need to be to come in and go, well, now I send me to ISF. It's probably going to be a revocation. It could be ISF, it could be a revocation, but you need to make those changes for good in your own life. Take advantage of whatever probation has to offer you. Okay? All right. Good luck to you. You can go back with the bailiff. You've got Norberto Armenta, Mr. Kimler.
I brought some of his certificates yesterday to the court, so that's stuff you didn't put in Harris County.
So it's a sentencing on the driving while intoxicated, and the evading is to be dismissed, correct?
Right. We're not asking for probation.
Right.
We're asking for 5.
I'm sorry. I know. I feel fine. It's just my hands are. And now there's a gnat or a fly flying around. I know it was. Good morning. You're Norberto Armenta, and this is cause number 25 DCCR 0168. Mr. Armenta was previously in court, entered a plea of guilty to driving while intoxicated, third or more, in addition to pleading true to prior offenses, making this a second-degree felony offense for punishment purposes. And there was an agreement of a cap of 12 years and to dismiss the evading as part of that plea agreement. I've received the pre-sentence report as well as a whole packet that the defense provided that has certificates and different things that I have reviewed. Has everyone had an opportunity to review the pre-sentence report as well as those other documents?
Yes, Your Honor.
Are there any additions or corrections?
No, ma'am. No, ma'am. No, Your Honor.
All right, Mr. Kimler, you may proceed.
Well, Your Honor, we start as usual with the criminal history, which is rather extensive, Mr. Armenta. I will say I've spoken to him at the jail extensively and reviewed the case. And this is really an unusual fact situation in that he's the one that called 911 on himself. in the vehicle because he was having I thought, and I'll let him explain it to you what the reasons that he did call concerns. And as a result of that, received the DWI. The evading detention, Mr. Armento, is from Harris County and has had some bad experiences with law enforcement. I think there was a low speed failure to stop. They did deploy the spike strip and he ultimately came to a stop. And he related to me that he was in fear, I guess, of law enforcement and wanted to get to a spot where he would feel safe pulling over. And that's what he did. But I'll let him elaborate as to his thinking on that.
Well, but what you're thinking is on that really isn't going to matter. You were on cocaine and Xanax at a minimum that day. So your thinking was not clear because you were under the influence of a lot of things in driving.
That's
okay.
correct, Your Honor. And I think that, he relapsed, I would say, because he has indicated, and I guess enough factually demonstrated that he is trying to maintain a sobriety through our religious faith-based rehab, or I'll say programming, but efforts to maintain his sobriety. The certificates that have been provided to the court were obtained by him while he was in custody in Harris County Jail. Awaiting transfer over here. He does have a motion to revoke probation in Harris County for a DWI that will be resolved after this case is disposed of. In the VSI, again, relating to criminal history, there's some self-reporting that Mr. Armento did as far as gang affiliations. I want the court to know too that these are self-reported by Mr. Armento. He didn't have to inform the probation officer. These are things that he told the probation officer in good faith about his history because he wanted to be honest about things. It certainly doesn't make him look good or any better, but it was important to him that he be honest about that. We're not asking for probation on this. It's a 12-year cap, and I think Mr. Armento really is in a better position than I am to give the court an indication of where he is in his life as far as his recovery, what his plans are, what his efforts have been. So I would defer to him at this point to talk to the judge and let her know where you are.
Did she get my college?
Yes, and he also, yes, there's some paperwork. He was in San Jacinto College, I think.
Right.
Yes, ma'am. Good morning. My whole life, I've been a criminal all my whole life. 2015, I began to change my life. I gave myself to God, and there's not much I can say, but I never, ever since I started doing recovery and trying to change my life, I had difficulties, and I was doing good and I relapsed. And Your Honor, I never dialed 911. And what they're teaching us is to take responsibility for your actions. And, and that's one thing that I wanted to do is I wanted help, and I wanted to get locked up for a while and take classes, and that's what I've done before. And that's the only way I knew how to get help. And I apologize to the courtroom for my mistakes that I've made, but I've never called 911 on myself, and I feel like that's a big step as well. As doesn't make it any better, I wasn't asking for probation, 2 years, 3 years, 4 years. I asked for 5 because I felt like, I don't know if that was a good punishment for me, but I felt like I needed to get away for a while from the wrong that I did, my mistakes. And I'll take full responsibility for my actions. And I'm sorry for what I caused. But I do have a daughter, and she's asking for me, and I'm just trying to better myself for her. And I never thought that changing my life would have to deal with me being an addict, and that's what I'm dealing with now.
Thank you. Thank you. Ms. Malfino?
Judge, obviously, his criminal history dictates that somewhere in the range of 10 to 12 years would be appropriate for him and would have been a sentence that was mitigated by the cap. I do appreciate his honesty. It's not what we typically hear from a defendant. Usually it's the excuses. I appreciate that he's not even asking for probation and insulting the court that way, so I'll defer to what he thinks.
So, Mr. Armenta, I make notes and go through the pre-sentence reports. Obviously, before court, I use a highlighter to highlight convictions and things, and usually the prettier it looks, the worse it is. With highlighting, yours does not look good. Your criminal history, like you said, is ridiculous. I appreciate what you're trying to do now. Obviously, it's a little late or a lot late, but it's Ms. Malfino's right. People don't take responsibility. I had a note on here for pretty much what she said, that 10 to 12 was probably the right thing to do. I think I'm inclined to give something for what you are trying to do, but 5 years is not going to be it. So I'm going to find that you entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty. And at this time, find you guilty of driving while intoxicated, third or more, find those prior offense true, sentence you to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Kimler. Good luck to you, sir. Hopefully you'll continue doing what you have been. Ms. Holmes on Claudia Villalobos. Let's see.
Thank you, Your Honor.
Yes, sir. I'll get you in just a second. I know.
You saw this?
Uh-huh. I missed it. All that dramatics, and I missed the dang thing. I didn't mean to scare everybody but it was right there and it landed. I didn't want to miss my opportunity.
Did you get it?
No. So be ready, just in case it comes back. I'm gonna whack it again if I have to.
Like a gnat or something?
Yeah, I think there's more than one. The one that was just here was like a bigger gnat. It was not. Mm-hmm. All right, are you Claudia Villalobos? And will your client waive the formal reading of the motion?
She will.
Ms. Villalobos, in cause number 22-39754. My computer's going slow.
Oh.
I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation September 12th of 2022 for the state jail felony offense of possession of a controlled substance, and that was a 5-year deferred probation. Is that correct? It alleges that you violated your probation. Count 1 alleges that you failed to report to the probation office as ordered July 10th, July 17th, and August 6th of 2025. And is that true or not true? Count 2 alleges that you provided a urine sample June 26th of 2025 that tested positive for methamphetamine. Is that true or not true? Okay, but so you tested positive around that same time, June 26th?
It was just
on the drug patch? Okay, so with that changed, that's true. Okay. And then count 3 alleges that you admitted to using methamphetamine July 24th of 2025. Is that true or not true? I'm sorry?
Yes, ma'am.
True or not true?
True.
Thank you. Count 4 alleges that you failed to provide verification of performing the community service hours as ordered. Is that true or not true? And then count 5 alleges that you're behind in your court assessed fees. Is that true or not true?
It's true.
And count 6 alleges that you did not abide by the drug patch guidelines. Is that true or not true? Did you enter your pleas of true to counts 1 through 6 freely and voluntarily? And because they're all true. I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? I've already probably done all that. All right, state tenders number 1.
No objection.
It's admitted. Any evidence that Ms. Villalobos is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your pleas of true to counts 1 through 6 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time, find you guilty of possession of a controlled substance. Sentence you in accordance with your agreement to a term of 11 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I have handed you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Holmes. All right, good luck to you, ma'am. You can go back with the bailiff. I'm going to do just one announcement real quick, and then I'll take care of you. Mr. Gertz, on no given name, Vishal.
His name is Vishal, Judge.
Vishal.
Like John Johnson or something.
Okay. Huh?
I'm sending the paperwork right now to Don.
Oh, did y'all do,
It's not agreed.
oh, okay. Sorry. I thought it was just sorry, Ms. Holmes. I thought it was just a quick,
What do you want to do?
he needs to, yeah.
Stand up here.
Well, he's going to need to be, printed. Go ahead.
That file looks like Trooper Priest did it. It is Priest. I'm just joking around.
There's nothing you cannot do.
He is nothing. And Tepe personnel. And then traffic. You can probably hear me right now.
Yeah. Somebody can, that'll probably,
Just so you know, Judge, we're doing an open plea to the negligent homicide.
Okay.
Obviously, we're setting for CSI because we don't agree. And we were talking about, I scratched out the language about the appeal because I think if he doesn't like the punishment, he's got a right to appeal.
if it's unagreed,
It's unagreed.
we always do that unless there's some,
Because there's a state jail felony, but there's no cap or anything here, so it's just unagreed.
it's just, if it's unagreed, it's unagreed.
Even if the punishment is within the range of punishment, even if the sentence is within the range of punishment.
I mean, that's what we do on all of them. Unless there's something that is given in exchange, there's another case that be filed or, just anything else, then it could be considered some type of an agreement.
Yeah.
All right. Are you Vishal? And will your client waive the formal reading of the indictment?
He will, Judge.
Mr. Vishal, in cause number 25 DCCR 0507, you're charged with the state jail felony offense of criminally negligent homicide from December 31st of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? Speak up,
You
please.
gotta speak up real loud.
Yes.
And are you pleading guilty because you actually did what they've charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Gertz? Speak up.
Yes, ma'am.
I need to hear you and she needs to hear you. Okay? So do you fully understand those documents that you signed?
Yes, ma'am.
And it's my understanding that you are leaving your punishment up to the court, up to me. I want to make sure you understand that you have an absolute right to have a jury come and determine 2 things. The first is to determine if you're guilty or not, and then you could leave your punishment up to that jury. If we go forward this way, you're waiving that right and you're leaving your punishment up to me. And is that what you want to do?
Yes.
State tenders number 1.
We have no objection, Judge.
It's admitted. Is there any evidence that Mr. Vichel is not competent?
No, Judge.
Also, Mr. Vichel, do you understand that a plea of guilty or no contest, if you're not a U.S. citizen, may result in deportation, exclusion from admission to the country, or denial of naturalization under federal law? All right. Then I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we will come back later for sentencing. Anything that you think is important for me to know, get that information to Mr. Gertz. He will present it to me on your behalf when we come back. All right, you can go back with the bailiff.
Thank you.
See Ms. Holmes on Mark King.
Mark.
There's nothing on this one, right?
Not yet, Your Honor.
Okay. Good morning. Are you Mark Anthony King?
Yes, ma'am.
And Mr. King is charged in cause numbers 25 DCCR 1063, 1064, and 1065 with aggravated sexual assault of a child in each of those cases. And what is the announcement?
Judge, it's really on me. I've been trying to get with the family of the victim and talk to them about a potential offer or anything in the case. I've not gotten returned to my calls.
Okay.
And so I'm going to keep trying. I have not been able to get in touch with them in the last few weeks. I've left messages on the numbers I have, and I just need to be able to get in contact with them, Your Honor.
All right, so I'm just going to do one more reset.
I think that
Obviously,
should be fine.
if you need to do anything to get them here, get that done and taken care of, and then we'll get an announcement at that next court date. If there's still issues at that point or at some point with you being unable to get them, if there's a request for a bond, then I would consider a bond reduction
Certainly,
as well if you want to get something filed.
Yes, ma'am.
Okay, you can go back with the bailiff. Yeah, okay. William? Mr. Mallett, in cause number 25 DCCR 1355, you're charged with the 3rd-degree felony offense of obstruction or retaliation from September 9th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they've charged you with? Speak up, please.
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you made with the district attorney that you will be waiving or giving up any right to appeal?
Yes, ma'am.
So if I follow the agreement, you can't change your mind later. You understand?
Yes.
And the agreement that you've reached, it looks like, is a 4-year deferred probation. There would be a $300 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? Okay. State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Mallett is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we will come back later for sentencing. Mr. Nichols, what is the state's position with regard to bond based on the nature of the plea agreement?
So this is pretty much the extent of his criminal history. It was an incident that occurred when he was intoxicated. As long as he's ordered to stay out of any bar or tavern or any establishment that primarily serves alcohol, I think we'll be okay.
So, Mr. Mallett, what I'm going to do, since you have reached this plea agreement, is I'm going to reduce your bond in your case to $1,000. If you make that bond between now and sentencing, there's a few things that are very important, okay? So the first thing is that if you make the bond, you go to the probation department as soon as you get out so they can do that report that we're talking about. If you don't do that, then you run the risk of me not accepting the plea agreement and things could be much worse. You understand? Do you understand?
I think
Yeah, I understand.
he's
Yes, I understand.
thinking about, because he did ask me financially, would the court consider a PR bond in this circumstance? Sees his family and their finances.
Yes, ma'am.
Where will you live when you bond out?
What's a PR bond?
Where will you, listen to what I'm asking, where will you live when you get out of jail? Where will you live?
Guess with my mom.
With your mom?
Yes, ma'am.
She's gonna let you live with her?
Yes.
Okay, so a PR bond means you don't have to pay any money,
Yes,
all
ma'am.
right? That means you just get out of jail.
Okay.
What's your position?
I'm just getting a hold on that one, Judge.
Yeah. I mean, $1,000 bond is 100 or, it's usually 10%, but I just,
I
feel
think
like
there just needs to be some recourse, even though
I don't know, just based on what's going on this morning, I'm having some concerns. That I want some check-in every week and things like that with the bondsman. And the nature of the allegations. All right, so I'm gonna leave it at $1,000. If you make the bond, great. If you don't, pay attention to what I'm saying, okay? Condition of that bond also is that you are not allowed to drink alcohol at all in any amounts. You are also not allowed to go into any bar where they just serve alcohol. It's different than a restaurant, but you cannot go to bars. Do you understand? All right, you can go back with the bailiff. Okay, thank you.
Hey, I'll call you. Okay.
Huh? Oh, are you? I know Kelly's had to restart and. Okay, let's see. Mr. Burbank, you've got Brandon Dodd.
Yeah, I found the motion.
Do you have something on Brandon Dodd?
It's still on our tablet, just been sent over here.
Oh, I'm so sorry. Yeah.
All right, sir, you're Brandon Dodd. Mr. Dodd, I am signing a dismissal in your case right now. So if there's nothing else holding you, you should be released today.
Your Honor, for the record, I've spoken with the family of the victim, and the court will recall the trial involving the co-defendant and the disposition that resulted in that particular trial.
Yep.
And the state believes, based on how that turned out, that there's a likelihood of a similar result.
Okay, all right, I'll sign it. Good luck to you, sir. Yes. Kevin Ross, Mr. Burt, well, he went to the back. That's okay, I'll get somebody else. Let's do, Quincy Batley, Mr. Lewis. Quincy Batley.
I'm trying to get through.
Okay, sounds good, thank you. Morning, Mr. Lewis.
Good morning, Joe.
How are you?
I told Hannah I was a little late this morning because I wasn't coming without my attachments. I was scared of them.
You guys, she's uh-huh. She'll get you.
Yeah.
Good morning. Are you Quincy Batley? And will your client waive the formal reading of the indictment?
He would.
Mr. Batley, in cause number 24 DCCR 11295, you're charged with the third-degree felony offense of unlawful possession of a firearm by felon from June 28th of 2023. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis? Do you fully understand them? And do you understand if I follow the agreement that you've made with the district attorney that you will be waiving or giving up any right to appeal? You also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law. State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Mr. Mallet is not Mr. Batley is not competent?
No.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of unlawful possession of a firearm by a felon. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Obviously, you know this, but I'm required to read this to you. Because of the judgment entered against you, you are ineligible to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. Good luck to you, sir. You can go back with the bailiff.
Mr. Batley.
I think they need a signature on something.
Just having seen it.
Let's see, Mr. Parker on Jason Jones.
Your Honor, we're going to ask that that be moved. That's the NQRP, and there's a new drug case, and that's all the allegations in that. I kind of need the discovery on that to.
I'll ask them to expedite, Your Honor.
Okay, yeah, since he's in custody,
If I make
let's.
the call, they can push it up.
Okay, sounds good. Thanks. All right, we'll reset Jones. Lauren Bridges.
I think my pen appears may stole it. Right, had to be.
I don't know. He would have used it, but I doubt he would have. He wouldn't have taken it with him. Yeah.
Well, he didn't have anything to write on, so.
Right. All right, ma'am, are you Lauren Bridges? And will your client waive the formal reading of the indictment?
She will, Your Honor.
Ms. Bridges, in cause number 25, the CCR 0354. You are charged with a state jail felony offense of credit or debit card abuse, and that's from October 16th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
And it looks like the agreement that you've reached is for a 2-year term in the state jail prison, but that would be probated. You'd be on probation for 5 years. You would be ordered to pay a $500 fine and to follow all of the rules and conditions of probation. Is that your understanding?
Yes.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
Objection.
It's admitted. Is there any evidence that Ms. Bridges is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing, and so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we will come back later for sentencing. I'm assuming, based on the plea agreement, that there's some type of history, Mr.
Judge, I'm
Nichols?
showing, I think, 2 prior state jail probations that I don't see a revocation for. Looks like they were both completed successfully.
And Your Honor, I provided, we originally set for a bond here. I provided the court and the state with letters. There's 4 letters. She voluntarily went to rehab from August. She got out October 27th. She immediately turned herself in when she got out. And I have those letters. There's 4 different letters from it's called Riverwalk Ranch. It's where she received her treatment. And of course, she got certificates of completion and things like that.
All right, so any objection based on all of that and the nature of the plea for a bond, a low bond or
I
PR
no
bond?
objection to it. Yes, I want to.
What was your drug of choice? Alcohol or some drug?
It was alcohol, methamphetamine.
Both, okay. So here's what I'm going to do. I'm going to reduce your bond. I'm not going to make it a PR bond because I'm going to order a drug patch. I'm going to reduce your bond to $1,000 based on the nature of your plea agreement. Condition of that bond is that you have to have a drug patch on within 24 hours of your release. So if you make the bond, talk to your bondsman, they'll let you know where to go get a drug patch on. Obviously, if you test positive for anything between now and sentencing, you run the risk of me not accepting this plea agreement. Things could be much worse. Also, if you make that bond, the first thing you do is go to the probation department so they can start that pre-sentence report. If you don't do that, you run the risk of me raising your bond and me not accepting the plea agreement. The last thing is that if you are arrested for anything between now and sentencing, if you make that bond, obviously you run the risk of me not accepting the agreement. You understand?
Yes.
Okay, we'll see you back at sentencing. You can go back with the bailiff.
Thank you, Your Honor.
Allison Strom, Mr. Parker.
Allison Strong.
Good morning. Are you Allison Strom?
Yes, Your Honor.
And Mr. Parker, will your client waive the formal reading of the indictment?
No, Your Honor.
Ms. Strom, in cause number 25, DCCR 1370, you're charged with a second-degree felony offense of assault on a peace officer, and that's from August 23rd of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you actually did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, Your Honor.
And do you fully understand them?
Yes, Your Honor.
And do you understand, if I follow the agreement that you made with the district attorney, that you will be waiving or giving up any right to appeal? So if I follow the agreement, you can't change your mind later. Do you understand?
Yes, Your Honor.
And it looks like the agreement that you've reached is for a 3-year deferred probation. You would be on the specialized caseload for any issues that you have going on, and then required to follow all of the other rules and conditions of probation. Is that your understanding?
With community service, correct?
Community service, reporting, drug testing, anything through MHMR, mental health treatment, anything like that, you will be required to do as part of your probation. Do you understand? Okay. And do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, sir.
State tenders number 1.
No objection.
It's admitted. I have to ask everyone that about the citizenship.
I'm American.
Everybody.
I had no doubt you were, but I have to ask everybody, okay? States number 1's admitted. Is there any evidence that Ms. Strom is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we will come back later for sentencing.
She's requesting a personal bond just because she doesn't have the means to bond down.
Judges, if I may.
And she can't, and I'm sorry, I think she wanted to go to live in Houston
Yes, sir.
with her mom in Houston.
And that would obviously be a better place for her than maybe here in Beaumont. I don't know if the court is familiar with probable cause. I haven't here. So it's not to really embarrass her in open court. There were some issues. The officers were trying to effect an emergency detention arrest for her own safety because there was a mental episode of sorts going on. And so my concern is that she would immediately go to MHMR or immediately go to her mom's house and remain there effectively under house arrest until some sort of evaluation and help for her can be put in
Right.
place so that she doesn't harm herself.
I guess my concern is during that period that she's not on probation, I'm not sure what access she has to Spindletop without it being court ordered.
Where did she go? She living?
Well, she's wanting to go live in Houston with her mom, and so I would want services obviously there. So that wouldn't be Spindletop, it would be Harris County, I can't remember.
They do have one.
I just don't know. It would be a condition of probation, but not a condition of bond. I don't think I can, so that's my concern.
Yeah, you are. Yeah, the judge can, yeah, but you just requested you go with your mom, but she says, she may have a place in Belmont she could live at.
Well, here's what I'm worried about is if I let you out on bond before we order probation and we have the conditions in place so that you can receive the treatment that you need, I need you receiving some treatment between now and then. Go ahead. Yeah, tell me.
I have a prescription I have the full prescription currently. Some of it's in security and then some of it's at my mom's.
Okay.
That was part of the issue. She wasn't taking her medication when this happened.
Okay. So you understand, obviously, at this point, that you have to take the medication.
Yes,
No matter how it makes you feel, good or bad, you have to take it.
No, I've been taking it every day while here and consecutively for the 2 months.
Good.
I've noticed a difference.
You feel better?
I feel I have a little bit more hope.
Good. So, All right, so here's what I'm going to do. I'm going to reduce your bond to $1,000. I'm going to make it a personal bond, which means you don't have to pay money. I'm going to order, so you're just going to be released today. But I'm going to order, I want you to go live with your mom. If that's the best place for you, you have medication there, she understands what's going on. So you're ordered as a condition of that bond to continue taking your medicine. You're ordered to go live with mom. You need to make sure you know how to get in touch with Mr. Parker. If something happens and it doesn't work out with mom and there's somewhere else that you need to go, you need to let him know so that I can give you permission to go there. Okay. Also, you're going to have to go to the probation department here as soon as you're released so they can start that pre-sentence report. Okay. Today, it depends on what time that you get out. So if you get out before 5 o'clock today, then it's better to go straight there today. If not, you'll go first thing tomorrow morning. Today, you're going to get some paperwork before you leave court today that has the address, where you're supposed to go and everything. So don't leave and go to Houston before you take care of that appointment.
I have somewhere I can stay for the day.
Okay, perfect. All right, any other questions? We're good? Okay, we'll see you back at sentencing. Robert Trahan, Mr. Parker.
I'll show you later.
That's awesome.
Yeah. And Judge, I'll just tell you, rejection, I'm gonna ask that, request Matuska. Matuska's his parole lawyer. So he has, I don't know, he's gonna request it.
Okay.
But because they had a parole hearing, so it might be, he knows about that, you know.
Okay. If he's working with him well, then I'm fine with,
Yeah. There's 3 cases, Judge. I did a separate one for all of them, but the Senate, the plea, the offer was all the same on all of them, just using different levels.
all right, so are you Robert Earl Trahan?
Yes, ma'am.
Mr. Trahan, in cause number 25, DCCR 1094, you're charged with the state jail felony offense of unauthorized use of a vehicle. The indictment alleges that you were previously convicted of accident involving injury or death, a special felony on October 16th of 2017. And after that was final, you were convicted of evading arrest or detention with the use of a vehicle, October 17th of 2022, and also possession of a controlled substance, a second-degree felony on that same day. What that means in that case is that if you're found guilty and those prior convictions are true, the punishment would be enhanced to that of a second-degree felony. So it would be a minimum of 2 years up to 20 years in prison. Do you understand?
Yes, ma'am.
And then in cause number 25, DCCR 1317, you're charged with possession of a controlled substance, a state jail felony from December 28th of 2024. It alleges those same prior offenses. And so in this case, also, if you were found guilty and if the those prior convictions were true, then you would be enhanced to second degree felony, which is between 2 years and up to 20 years. Do you understand?
Yes, ma'am.
And then finally, wait, hold on. In cause number 25, DCCR 1536, you're charged with a third degree felony offense of, evading arrest or detention with the use of a vehicle from August 20th of 2025. The indictment alleges those same prior offenses, which in this case means that you would be considered a habitual offender with a minimum punishment of 25 years in prison up to 99 years or life. Do you understand?
Yes, ma'am.
In all of these cases, I have here on the tablet, the plea bargain rejections that you've signed with Mr. Parker. This shows that the district attorney's office has made offers if you wanted to enter pleas of guilty for 10-year terms in all of those cases. And so that would mean in that last case, the evading going on count one only for the 10-year term to run concurrent, all three of them. You have every right to reject those offers and have your cases set for trial. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are. And do you understand all of that? And do you want to reject those offers and have your cases set for trial? And Mr. Coleman, is there any reason to anticipate that there's any other evidence that you haven't received that would change that offer?
Not at all, Your Honor. In fact, the state will be filing a motion to accumulate the sentences in all three of these cases.
So I do want to make sure you also understand because these are different offense dates, there is the potential, if you're found guilty in all three of the cases, that any sentence that you received from a jury could be stacked on top of each other. Do you understand that as well? And that after today, I will not accept this plea agreement. You understand? All right, then I will get your cases set on the trial docket. Mr. Parker has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and I can appoint another attorney who could begin preparation a little quicker. Is that okay with you? All right, Mr.
Your Honor, I'll just, as I've told the court, he has Brian Matuska as a parole lawyer, and he would be found with his institution, but it's obviously up to the court.
I'll take a look at it. Typically, it's just a rotation. If Mr. Matuska is already handling something for you, we'll contact him, and if that works out, we'll appoint him. If not, then it'll just be somebody off the rotation. Okay, you can go back with the bailiff. Mr. Adams, you have Travis Smith.
Hold on, can I just take 1 second to say something to somebody outside?
Yeah.
Here's kind of a snapshot of him, Your Honor.
Hang on a second.
I've given it to the DA.
Well, we're not doing anything today, right?
I was gonna ask for an order to have a mental examination, so he's in jail right now.
All right, so are you Travis? Hold on, are you Travis Smith?
Yeah, I'm good.
So I know there have been some documents filed by Mr. Adams with regard to a mental examination. I think there was some confusion as to what you're asking for. First of all, you're hired in the case, correct?
Yes, ma'am.
So anything that is filed requesting a court-appointed examination needs to include an affidavit of indigency sworn to. So I need you to get that taken care of and attached to anything you filed if you haven't already.
Well, it's not indigent, so we might have to.
Okay.
Go far up, and I'm not gonna follow that.
Okay.
For that reason,
Okay, I mean, there are times when someone can
Yeah.
hire an attorney,
Yes.
but they run out of money or whatever it is. If that's not the case and he's not indigent, then I'll reset the case to give you a time to have someone get that examination taken care of. But if it's a hired case and they're not indigent, that would be something that the defense would take care of. So
Well, I could still have, I think I have an order that would allow that. Let me look through it here. I look the order different ways.
I guess what I'm saying is I'm not going to sign an order having the county pay for it unless there is an affidavit of indigency.
I'm not asking for the county. That's what I'm saying. I have an order that where we do it.
Well, I don't know that, I mean, I'll order it, but I don't know that you need me to order it. If it's your client, you can have him examined. Is there, you know what I'm saying? Do you need me to order it? If it's
No,
your,
I can get him examined for, it's present competency.
okay. But I don't think I need to order it. I think you can just have a doctor go, if that's
Or a
between,
PhD can do it too, I think.
yeah,
Yeah.
yeah. So I'll reset it to give you some time to get someone to go out there and take care of whatever examination that you need to, and then we'll get an announcement at the next court date.
Okay, but what are we gonna, What I want after that is, to put him somewhere where he can't afford this.
Well, we gotta get the
State
examination.
hospital,
Let's take
yeah.
one step at a time.
Yeah,
Let's get the
that's the second.
let's get the evaluation
Well,
done,
that's
because
the
if
first
he's
thing.
not competent, then I can order
Yeah.
him go to the appropriate facility. All right? All right, so you get the examination taken care of.
Have to get you examined to make sure you're confident in what's going on. But when you know,
A doctor is going to come visit with you and just talk to you about your case and what's going on and make sure you understand everything. And then we'll go forward after that, okay? Because that's what we're going to take care of. That's what your lawyer is recommending. So that's what we're going to do. So you can go back with the bailiff. Mr. Adams, the quicker you get that done, the better, so that whoever's going to do it can get out there and get that taken care of before the next court date.
all right, yeah.
Okay, thanks.
When's the next court date? 30? I don't know.
I don't say, that's out of my pay grade.
Okay.
May I approach it?
Sure.
Once you get evaluated.
Apparently everybody else could get through those traffic lights but me. Court does call the case of Haverville on Clark versus Jeffrey Thompson.
Good morning, Your Honor. Jay Baig, P 36820 on behalf of plaintiff.
Good morning, Judge Simpson. It's Jeff Thompson.
All right, you can take.
Oh, sorry.
All right,
Oh, sorry. Oh,
Well, we had a hearing maybe a week or so ago, and you instructed Mr. Thompson to file an answer by the 26th of last month.
I think I gave him to. Well, hold on. Yes, I did. Right, you're right.
He said he filed it. I checked with the clerk here, and it may not have been received by the court. He said that he mailed a copy to plaintiff's counsel. In any event, I had him email me a copy, maybe about half. So I'm in with a copy of his.
unfortunately, Judge Simpson, the court doesn't even have the representing attorney's email on file. There's no website online that we can get the email from. The telephone number that we call with my CMH case managers is just a generic telephone number with no idea whether or not it's a law firm or not. The information was sent electronically. We called the court to make sure that it was.
Well, hold it. You received paperwork at the beginning of this case.
What do you mean?
Well, you received the complaint, right?
Yes.
And if I'm not mistaken, counsel, the complaint has your. The complaint has all of counsel's information.
Yeah, it's not. The information was sent to his office. The girls, I just checked with the clerk's office. It was received on Wednesday. They said that they're going to walk down. You found a copy today.
I'm not going to make an issue about the answer. I mean, he.
Yeah, it just came in this morning. Do you have a copy?
Yes, exactly.
You do. Do you have a copy?
I do have. Yeah,
Okay.
I had a meeting.
All right. Let me just see this because I have not.
Okay. Settlement is not likely. I believe this is going to go to trial. So I think we're going to set some dates.
All right, what primarily is the issue in this case, Mr. Counsel, from your standpoint?
I had psychological challenges, which I just recently went inpatient for. I know about some mental health issues. And just recently been taken care of. We started a whole new medical regimen. We're slowly going to tweak them over time. I've got 2 different psychiatrists that are calling me, 2 of them. I'm now involved with case management and with CMH, which has all been really helpful. It's just, there was a lot going on at the time. My dad just died a couple of days before the event, and my mom's in a nursing home right now. So, there's a lot, and I know that that's ancillary to this case, but it's affected me in a lot of different ways that I never thought possible. It's really brought up a lot of the behavioral health and mental health issues. So I've got a grasp of them. I'm doing well. I've never bothered anybody at the apartment complex. I love my neighbors. They love me. I thought I had a great relationship with the staff there because they're always really nice to me. I wouldn't have a reason to think otherwise. I don't want to lose my home, and I'm feeling a lot better now. It's just, it's really hard, So even standing here right now, I get nervous when I'm in here. I'm nervous in front of you, and this guy makes me nervous. It's just, a long time ago, I couldn't tell you. I just run the opposite direction.
And so in terms of the specific behavior, is your client open to any type of probationary agreement?
I was thinking about that. I don't believe so. They're pretty adamant about terminating the lease. There were 2 incidents, as noted in the notice to quit, which is part of the file. I won't get into the details here, but it's.
I was sick. Your Honor, I'm sorry.
Yeah.
I gladly admit where I'm wrong. I know where I'm wrong. I didn't know what I was doing at the time, and with the person I was dating, and I'm sick. I'm doing what I need to do now to get the help that I need, and it's really intimidating to be up here right now. So, and it seems like it's every couple of weeks that I have to come back, and I know it's a process, and I know that.
Right, but I guess what I'm. Do you have? Have you tried to provide or provided any type of medical documentation, even for plaintiff's consideration in this?
Yeah, I tried to, and we tried, because it said in that first notice that they were trying to talk to me within the first 10 days. And Latasha, the property manager, was really nice. She tried to work with me to get that, but I guess it was her manager that said no, that she didn't want to talk. Within 10 days of receiving their paperwork, she said that they had to talk to me, or they could talk.
Right, I get that reading. What I'm indicating is, and if what you're telling me is not what you're telling me, then tell me that, okay?
Okay.
But as I'm understanding it, you are having mental health episodes that led to these incidents.
Yes.
Okay. I'll just ask you this. What do you have that would tell me that's the case?
They've diagnosed me with bipolar, generalized anxiety disorder, and clinical depression. I also have an autoimmune disease.
Okay, but I realize it doesn't work specifically this way, but on the dates of these particular incidents, what do you have that would tell me or anyone else that it was some type of episode, manic or other?
I'd have to get it from the psychiatrist at Michigan. I'm sure they can give you documentation of it, or let you know what happened. They can give you the documents.
Okay, then maybe I'll ask another question.
Sorry.
No, it's okay. after each of these incidents, did you go to a healthcare professional?
Yes, yeah, I was seeing a therapist and the
Yeah,
psychiatrist.
but how soon, like, the incident occurs, how soon did you go?
Probably just a days afterward, if it was even a day. They have the information.
And you went because?
I was scared. I didn't know what was happening to me.
Okay. And that occurred on both of these incidents?
I believe so, yeah. They did.
Okay, and without getting too much into what may have been told to you, your healthcare treatment providers, they said that you were suffering from something at that point. Is that what you're telling me?
Yes.
Okay. That information, have you provided that to plaintiff at all?
No, not yet, because I didn't think we could. I'm sorry.
Pardon?
After they said they didn't want to talk to me, I didn't think they needed it. I can give them a copy. I'm sure the doctor can even call them if they wanted to as well.
Well, that gets into a whole other complicated thing, but
sorry.
All right. So let me ask you this. If you don't provide that, what would you be at? What are you asking the court to do?
I don't want to lose my home. I've done everything that I can over the last several years to acquire, and I came from a really bad place at Arbor One prior to that time. And just
were you?
I just trying to deal.
Were you residing when? How long ago were you residing at Arbor One?
Last year, for a couple years.
And you moved from Arbor One because
was condemned by the state of Michigan.
Yeah. Okay.
I'm sorry.
So who relocated you?
It was the Section 8 vouchers.
Got it.
Yeah, maybe we set up for another settlement conference, or at least give him time to provide counsel the medical documentation that
they can do that.
Yeah, and so remind me, how long have you been in this unit?
Since June, beginning of June. Latasha tried to get me in as quickly as she could because they were really helpful.
Beginning of June of this year.
Yeah.
And then this, okay. And you moved right from Arbor One into.
Yeah, because my building was really bad there.
What was your address there?
723.
Green?
Yeah.
Okay.
I just feel
it's amazing. I know. Well,
next.
Pardon?
I just one thing after the next. I'm sorry. I don't want to sound.
No, it's counsel. I don't know if you know anything about that whole situation.
I don't, but I think I'm getting a flavor of it now.
Yeah, and so I'll just say it this way: he would have been one of the individuals, in particular with the address that he's given me, that was for probably an extensive period of time sitting in a condemned building.
Yeah, I have mold inside my system too. I got really sick while I was there. The doctors have that on file.
Okay. And so there was just to give a sort of a sketch of it, there were initially cases that were filed before me. They were removed to the circuit court.
Mm-hmm.
The county prosecutor filed a civil claim along with the city of Ypsilanti. Thankfully, in a lot of ways, it went away from me and it was in a circuit court. There was in a federal court, and all of that is pending.
We appreciate what you did, though.
Pardon?
We really appreciate what you did. You really helped a lot of people. including myself.
Well, thank you for that, sir. I do appreciate that. So here's what I'm gonna do. I'm gonna set a new date, but here's what I'm gonna want you to do. You got, your worker's not here today, right?
No, I got to go see him after it. There's a 2-hour therapy session after this at 12:30.
Okay. So what you're gonna need to do is provide medical documentation to plaintiff's counsel.
Okay.
I'm also going to want a copy to the court, but here's what I'm going to tell you. Tell them when they bring it to the court to put it in a sealed envelope.
Okay.
And addressed directly to me.
Okay.
Okay, because what I don't want is, I don't want, to any extent that we can avoid it, I don't want all of your medical in a court file.
Okay.
You follow me?
Yeah, I do.
All right. So how soon do you think you can get that done?
I can, if we're on my team, so I'll get it to you right now, but I don't know what theirs is. Maybe.
Okay.
Is that okay?
Just slow down a bit. Just, give you time to get it so that plaintiff's counsel can have time to consider it and the court can look at it and just try to figure it out. When's my next day?
Your next date.
Thank you. Thank you.
Yeah. Okay, that's not going to be enough time.
You got to give them more time. Yeah, more time than that.
Okay, here's what I'm going to do. I'm going to go to January 6th. I'm not going to take the December date. Okay. But, so I'm going to adjourn the final settlement conference. January 2026 at 9. Okay. Send Barbara Woods versus Adriana Owen. We don't see her like forever. She was just his head on the the Zoom screen. And now this is like the third time. Not that I'm counting. Hello, go ahead.
Good morning, Your Honor. Casey Matson, P87729 on behalf of plaintiff.
All right. Your name?
Adriana.
All right. Where are we on this case?
Your Honor, we did have a chance to discuss. We did come to an agreement. Not sure if you would like it in the form of a conditional dismissal or a separate order and dismissal. I do have a conditional dismissal prepared here for you.
Okay, well, we can maybe do it that way. What do we have?
Your Honor, we did look over the numbers and agree to an amount. The rent to retain is $3,632.63. Court costs of $186 for a total of $3,818.63. Your Honor, there is escrow in the amount of $3,906.21 held with the court. We did agree that should be released to plaintiff and applied towards that amount, which would again leave her with a credit on her account for January as well.
And so then she would satisfy the conditional order dismissal.
Yes.
Yes. You're just smiling. Words didn't even come out of your mouth. Is that agreeable to you?
Yes.
All right. Okay, I'll do it this way just to make sure. And we do have, and I would verify that we do have the escrow amount that's listed here in the court file. So we'll send that over. Do you have any questions regarding this conditional order dismissal?
No, sir.
All right. None?
None. I already asked the questions that I had.
Well, she represents the other side. So I know she was probably really nice to you and answered all of your questions.
She cleared it up. It was the paper that she presented to me with the numbers that they came up with.
Okay.
So she cleared it up. So
Okay, in terms of the accounting. Okay, so you're good with this.
I'm good. You can't do me no more.
Well, it's not that I don't want to see you. Not like this. All right. All right. You can come by and just say hello. But All right, listen, I do have to advise you, since this is a conditional order dismissal, that you have 3 business days to think about this. If you
Okay.
believe that there's some legal reason, some right you didn't assert, some confusion on your part, you'd have to file a motion with the court within that time frame.
Okay.
Doesn't mean that I would grant it, but you'd have to do that.
All right.
All right. Okay. Whoops. I will mark this file conditionally dismissed. I've signed the order. And counsel, I don't know, Ms. Dornbush sometimes was, I don't want to say this. She wanted to make sure her client got the check right away.
Mhm.
And so she asked me, okay, it's Dornbush. She demanded of me to have the check prepared in a couple of cases. Did you wish that done today? Because we can try to arrange that. And she took the check with her, but I don't know if you want to.
Your Honor, I'd just prefer it be mailed to our
All right,
office.
we'll mail it out.
I can do a separate escrow, order releasing escrow if that's necessary.
It's not necessary.
Okay, thank
All
you,
right.
Your Honor.
Thank you guys for working it out. You take care.
No.
All right. And you know what?
Bye.
You say, I'm sorry, I interrupted you. Thank you. Two out of 3 down. Now something tells me everything's gonna go sideways. Court does call the case. I shouldn't say that. Jerome versus Cassidy. I have people on.
Yes.
Good morning, Your Honor. Gail Rosen appearing. Yeah.
Your Honor, Abby Cooper appearing on behalf of plaintiffs, the drones.
Joe Lloyd, Your Honor, appearing on behalf of Mr. Cassidy.
Okay. And then Ms. Tepe is here. I do. Yes. All right.
I am appearing on behalf of Cambridge Family Holdings, plaintiff and counter defendant in this case.
All right. So I think probably the first thing that we may need to deal with is, Ms. Rosen, your motion to withdraw.
Thank you, Your Honor. I do want to make one correction. I noted in my motion that Mr. Lloyd is co-counsel for Ms. Cassidy. I learned after filing the motion that this is not correct. It was my assumption that Mr. Lloyd was representing both Eric and Paula Cassidy as he replaced Francine Ovar, who's been representing both Paula and Eric. She and I were co-counsels representing Miss Cassidy. I've since learned that Mr. Lloyd is only representing Eric Cassidy. But as I stated in my did you have a question, Your Honor?
Well, no, go ahead. Go ahead.
As I stated in the motion, as Miss Cassidy is not eligible for services from our office, student legal services, we're unable to represent her. She needs to both be currently enrolled at University of Michigan and current on her tuition. We routinely check with the registrar's office to determine eligibility for our services. And since, as I indicated in my motion, she has not paid the tuition, which includes fees for student legal services since fall of 2024, she is not eligible for our services. It's my understanding that Mr. Lloyd is going to be requesting an adjournment of today's hearing or an adjournment of time to file the answer, which would provide ample time for Ms. Cassidy to hire new counsel or seek representation from Mr. Lloyd, who is already representing Mr. Cassidy in this matter. As such, I don't believe that our withdrawal will have a material adverse effect on Ms. Cassidy or her interests.
Do you have anything to say regarding the motion?
No, Your Honor, plaintiffs do not oppose the request.
Mr. Lloyd.
I think what she said is true. I don't have a dog in this fight either. I do not represent Paula Cassidy, as I understand it. And I think she has filed a document with the court. If you've seen it, sort of laying out what she wants to do. But I don't speak.
Who, Ms. Cassidy?
This morning, she filed a 2-page response. I filed for her, and she can't be here. And she's
I got it. it came in. I have not. Oh,
You don't mind. She opposes, but she really is just asking for.
I got, thank you. Hang on. Have you not seen this, Miss Rosen? I take it.
I received it this morning, Your Honor.
And maybe you can. She says she is enrolled as a graduate student.
Tuition has not been paid, Your Honor, which includes our fees. So a student has to be both enrolled in classes
And pay. Got it. Okay. Okay. So she goes further on to say, are we really talking about $8.50? Or
No, the $8.50 is what our student legal services fees are. It's included in the tuition. So tuition has to be paid in order for students to be eligible for our services. It's part of the tuition.
You wanted to say something, Mr. Cassidy. I mean.
Yes, Your Honor, just as you know, she can't be here, she's in class. I know she would disagree with what Ms. Rosen is saying. There's an engagement letter. Does not require tuition to be paid. But the second part of it that Ms. Rosen does know is Paula has a payment plan with the registrar, in part because she's good for cancer treatment. Why Ms. Rosen hasn't told you that, I don't know. But she's been told by the person who runs the clinic that the actual fee at issue is $8.50. Paula has complied with the engagement letter 100%. She's currently enrolled and has a payment plan with the registrar that Ms. Rosen doesn't have access to, but she's been told that's the case. So really, this is somewhat unfortunate pretext, as I think Paula says. More than anything, she wasn't given notice that this was going to be heard today, and she would like some time. If there's some resolution that can be emailed at SLS, great. Then if not, she'd like an opportunity to be here and explain her position.
Your Honor, if I may, the information that we received from the registrar's office. The only information that the registrar's office provided to us is that the tuition has not been paid. I don't have anything further from the registrar's office. Additionally,
okay. Would it be your understanding that if there's a payment plan that they've approved, that would suffice for the purposes of continued representation?
I don't believe that it would, as our fees have not been paid. I mean, the only information we get from the registrar's office is that the tuition has not been paid since the fall of 2024.
Okay, but I guess I'm a little bit confused, only because if a student was waiting on financial aid from get there, but they know that it's coming, I don't know that it would and they're still attending classes, everybody's just waiting on the funds to get there. That may place them certainly in a circumstance where hold on one moment. Who was that? Oh, just tell her to walk in.
No, I'm gonna go tell.
If she's got something.
No, she's gonna.
Okay. Anyway. I don't answer knocks at the door. All right. So if it would seem, I guess somebody, given her objection, somebody would have to clarify for me that if she has a valid payment plan with them, why that does not then provide for her to have access to the services.
Usually, Your Honor,
Go ahead.
in a situation where where a student is waiting for financial aid, that's usually paid within a matter of weeks. This has been over a year or almost a year at this point that the fees have not been paid, the tuition and fees have not been paid. And I also think, Your Honor, at this point, not to switch gears, but that at this point, I believe that there's been, in addition to the tuition issue, there's been a breakdown in the attorney-client relationship. I have been advised that it's Miss Cassidy's opinion that I am incompetent and unethical. I don't think that that's the basis for a continued attorney-client relationship.
Well, I was going to get to that next, and I'll just say this, and I understand people can have their views of attorneys and everything, but I'll just say it, that's not you.
Thank
and
you, Your Honor.
That as I read those statements, that you were somehow unethical with her or misrepresenting her, trying to provide a pretext, and then not only doing that to a client, I don't believe that at all. But further, that you would take that and provide that same information, some false representation or some misrepresentation to this or any other court. That has never been the way that you practice. It is not you. And quite frankly, I don't believe it. So I'm just going to lay that out there.
Thank you.
I would then indicate, I think you're right, that I will grant the motion to withdraw, but not on the basis of the failure for the tuition to be paid. Because otherwise I'm going to get into a whole big whatever of, does a payment plan qualify? Does it not? Has the actual fee for the representation be paid? And I don't know that in the long run that's going to matter, because if I were to then deny the motion, Ms. Rosen and Ms. Cassidy would then I would then get another motion, quite frankly, asking that Ms. Rosen would be asking to withdraw because of a breakdown in the attorney-client relationship. And I would agree with that notion for the basis for withdrawal, particularly given the statements that have been made on this. And I'll just say one other thing. I've been involved in this case since its beginning, and I don't know the conversations that take place between attorneys and counsel, but I can tell you that, to the extent Ms. Cassidy can hear me on this, just understanding that Ms. Rosen has been a ferocious, and I don't mean that in a bad way, but a huge advocate for her and zealously representing her in every moment that she's appeared before me or when we've had our bench conferences. So I'm going to permit the withdrawal on the basis that the attorney-client relationship is broken down. That may be, quite frankly, to Ms. Cassidy's, certainly not to her benefit, because I think she had one of the best attorneys we have out there. So I don't know how much time she has indicated a certain schedule here, but I don't know how much time she's going to need to get an attorney to represent her in this matter. Mr. Cassidy, you have any idea how long?
A week to 2 weeks. We started working on it. However, this motion was given to us on a Tuesday for Thanksgiving, so.
All right. Before I do that, is anybody going to have an objection given the circumstances to an adjournment? I'll hear it, but I'm going to adjourn it anyway.
Your Honor, adjourning the motion regarding
Well,
jurisdiction or adjourning?
I'm going to adjourn everything because I don't have somebody representing Miss Cassidy. I'm ready to hear argument certainly on that, but I don't know if Miss Cassidy's going to have a different position. So.
Okay.
And it may not matter. I get
Yes,
it.
I understand. Well, I guess the motion, just as a practical matter, the other motion before the court today is the motion for the court to obtain concurrent jurisdiction or to remove to circuit court. There was no objection filed by anybody. Is the court still inclined to adjourn that as well?
Yes.
Okay.
I understand why I may not, but it seemed, given Ms. Cassidy's objections, that she was much more preoccupied with the withdrawal counsel. So I don't know if that was addressed.
Okay.
Put it that way.
Then, Your Honor, I would request we have a specific time frame. It sounds like they were open to 1 to 2 weeks to obtain new counsel. And then moreover, the court had previously requested or ordered that the defendants answer any amended pleadings as of yesterday.
Yes.
That did not occur. So we would further request that a new deadline be ordered by the court and that it be honored for answering the complaint and filing any counterclaims.
And that was from the Cassidys. That was-
Correct.
Right. Mr. Lloyd.
I'm perfectly comfortable with adjournment. I do need more time to properly address the claims that are made. And I was going to be making the same request the same relief for different reasons.
Got it. Okay. So I love scheduling things in December. And I have the 2nd, 9th, 16th, and then January 6th. Quite frankly, I think the practical is going to be January 6th because by the time counsel gets involved, that's going to give you enough time, Mr. Lloyd.
Yes.
By the time Ms. Cassidy gets counsel, they've got to figure out what's going on and get an answer. So I'm going to set this for the 6th. Answers by both Mr. and Mrs. Cassidy need, as well as any counterclaims, would need to be filed our last day before the holiday being open. Well, I'll give you 3 weeks to get that done. So by the 23rd of December. Will that work?
Yes, thank you.
Yes.
All right. Is there anything else from anybody else? Ms. Rosen, did you file a proposed order with the court? I don't.
No, I will
No,
submit
no.
one though.
All right, please do that. And why don't we do this in that order that I've allowed to withdraw? If you could include those future dates and when the answer's due so that once that's served by Miss Cassidy, she'll know. So if you could do that for.
Sure,
us, I'd
could you just
appreciate it.
remind me of the dates?
Yes, the new, I guess we're the 23rd of December. The defendants, counter plaintiffs in this case, are to answer the complaint and file their counterclaims by that day,
And then returning to court January 6th?
January 6th, 9
At what
a.m.
time? 9 a.m.?
9 a.m.
6th is a Tuesday.
It is.
Thank you.
And that's to hear the motions and for us.
That's it. Yes, hear the motions, and I think I've got to hear the motion before I can decide whether what we're going to do. So,
Understood.
all
Thank you
right.
very much for your time, Your Honor.
Thank you. Thank you, folks.
Thank you.
Thank you.
Thank you, Your Honor.
We have one new judgment to
Okay. Let me see here. I'm gonna find these real quick. Anna, would you print the MTRP on 1199, please? And I'm gonna print the other one real quick. Give me just a second. All right, give me just a second. All right, so are you Kevin Damon Ross?
Yes, ma'am.
And will your client waive the formal reading of the indictment and the motions?
He will.
Mr. Ross, in cause number 251310, you're charged with the third-degree felony offense of evading arrest or detention with the use of a vehicle from June 13th of 2025. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with? I have here on the tablet some documents in that case that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Burbank? Do you fully understand them?
Yes,
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1, it's admitted. Is there any evidence that Mr. Ross is not competent? Look at something real quick. I'm printing something else. Sorry, I'm trying to find the pre-sentence report real quick and the
underlying.
I think I've got it probably in this case. I think I was looking at the wrong one. Yeah. Obviously, I'm looking at not 11, how quickly he reoffended. with the same thing. And truly the outlandish way
Yes.
in which he did it.
Judge, we had an honest discussion about the fact that the court might reject that. And if so, that would be completely understood. And we would be happy to go back and discuss it further. And at that point, it may be best to just go open on the MTRPs and allow me to prove up all of those administrative violations. That way you have everything kind of at your disposal. He doesn't have any felony criminal history, but obviously the new offense was egregious as well as the underlying. So Mr. Burbank and I will have discussed that.
I don't see the PSI in either of mine, Anna. Maybe I'm missing it. But Ms. Malfino had it, but I'd like to see that entire PC. I mean, see why it's not there. Yeah, so the first time in March of last year, that offense. Sorry, I'm just trying to get a look at the whole picture. Give me a
Here's
second.
the PC on the new law.
I've got that already. Thank you. This is the one I need to. All right, I'm printing one more thing as well. I can't, the PC's come up on my computer looking like a foreign language. So the first offense that you're on probation for, there was a actual accident. Okay, and then the new offense starts in Port Arthur. I mean, 127 miles an hour or more.
I question that, Judge, because I did see the video. And I don't think that car could go 127 miles an hour.
It's a pretty specific speed for the cops to be saying.
Probably what he had to do in order to catch up.
Nearly struck other motorists, splitting the lanes. Had to advise DPS, Jefferson County, Port Arthur, Groves, Nederland, because he's going all over the place. Blacking lights out. Yeah, no, I'm not gonna accept this agreement on the motions. I'm gonna delete the paper. Well, we can do a couple things. We can either go forward. Let me get pleas on the motion of true or not true. If he wants to plead not true, we can have a hearing. The state can bring evidence. If he wants to plead true, I'll get an updated pre-sentence report and we'll have a hearing on sentencing.
I'm gonna have to ask that to withdraw everything, Judge, and give me a little bit of time so I can try to figure something out.
Sure. I do want sooner rather than later to go through the motions and get pleas of true or not true. So at least that moves the case forward, because once we do that, then we're going to still reset it for a hearing.
If you just give me couple of weeks, or a week and a half, I mean, depending on what happens.
Let's set Mr. Ross on Tuesday, the 16th. We're gonna be busy on Tuesday, the 16th, and I'll delete all the paperwork and withdraw everything. You can go back with the bailiff. So I really don't know if I need. Oh, Ms. Martino, this is yours.
And I can.
Oh, yeah, if we have to, well, we could do that too. Well, I think I will want an updated report though. Maybe,
Just let me know if you change.
maybe I don't.
I'll just,
Okay,
I'll get the probation officer.
yeah, okay, sounds good. Mr. Burbank, and if you'll let Ms. Malfino know prior to that date, if you anticipate him pleading not true to the new offenses, because if he's going to, and we have time, we can have a quick hearing where she could, we could go ahead and get that done on the 16th and be done with it.
I just need to take a look at everything, Judge.
Sure. Okay. I don't think I need any of that. Delete.
You could get it done. Yeah, no, that's fine.
Okay. Mr. Lewis on Gerald Downs, 2 cases. Would you sign both of those, please? Good morning. Are you Gerald Downs?
Yes, ma'am.
And will your client waive the formal reading of the indictment in each case? Would you fill in the dates on those for me, please, ma'am? All right. Mr. Downs, in cause number 24, well, let's see, what counts are we going on? Count one only? All right, let me get that pulled up properly. Is that in both cases?
Yes, sir.
Okay, thank you. All right, and cause number 24, DCCR 0566, the state has elected to proceed on count one only. It alleges you committed the 3rd-degree felony offense of evading arrest or detention with the use of a vehicle from January 28th of 2023. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
Give me a second to pull the other one up. Sorry, it takes a minute for me to pull it up the right way so I can make those notations. All right, in cause number 24, DCCR 1023, the state's also elected to proceed on count one only. It alleges you committed the 3rd-degree felony offense of deadly conduct discharging a firearm from January 28th of 2024. And how do you plead to that charge?
Guilty.
And are you pleading guilty freely and voluntarily? And because you did what they charged you with? In each of these cases, I have here on the tablet some documents that have your signature on them. Before you signed these, did you go over them with Mr. Lewis? Do you fully understand them? And do you understand if I follow the agreements that you've made with the district attorney that you will be waiving or giving up any right to appeal? Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tender's number one in each case.
No objection.
It's admitted in each case. Is there any evidence that Mr. Downs is not competent?
No objection.
All right, Mr. Downs, in each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of those pleas. In cause number 24, DCCR 0566, find sufficient evidence to find you guilty, and at this time, find you guilty of evading arrest or detention with the use of a vehicle. Sentence you in accordance with your agreement to a term of 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 24, DCCR 1023, also find sufficient evidence to find you guilty, and at this time find you guilty of deadly conduct, discharging a firearm. Sentence you in accordance with that agreement to a term of 6 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will run concurrently, which means together at the same time. I'm handing you the trial court certification in each case that shows that these were agreements that I followed, and so you've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. It's my understanding, is there already a federal sentence that you're serving?
It's already been sent.
So did they specifically
They said that it would run according to.
concurrently?
Concurrent.
Okay.
According to.
So I will also order that it's really up to the federal system on whether things run concurrently or not with state. I can say whatever I want and they're going to do what they want. It's my understanding, though, that they've said that this will run concurrently or at the same time with your federal sentence. And so I will make sure that our judgments notate that as well, so that both of these will run concurrently with each other and the federal sentence. If there's something different that happens on that, that's up to them. Okay. All right. You can go back with the bailiff. Good luck to you, sir.
Thank you.
Yes, sir. Let's see. Gregory Griffin. This is a competency.
Yeah, we just got the report back.
He's not.
He is.
He is. Okay. So you just need some time.
Yes, ma'am. It's some videos I need to look at with him.
I'll make let me go ahead and make that. I'll make the finding of competency and then I'll reset it. What I do.
Your signatures didn't.
Oh gosh, on any of them?
I don't know on this one for sure.
So you're Gregory Griffin,
Yes, ma'am.
and this is 25 DCCR 1018. Mr. Griffin was evaluated by Dr. Hamza for competency to stand trial. I'm going to take judicial notice of the court's file, which includes the competency evaluation report dated October 8th of 2025. The finding in that report is that Mr. Griffin is currently, competent to stand trial. Is there any other evidence with regard to competency?
No, Judge. No, Judge.
All right, then at this time, based on that report, I am going to find Mr. Griffin competent to stand trial. And at this time, now that we have that report, I'll reset the case so that you can have some time, Mr. Lewis, to go out, visit with Mr. Griffin about everything and all the discovery he's received. Y'all can talk about that and we'll get an announcement at the next court date. All right, you can go back with the bailiff. So you have Jonay Landrio.
Oh, Judge, with her, I'm gonna have to get her evaluated. Evidently, there was also some issues this morning
Okay.
with her and,
I'll reset that, just get the order over and we'll get it taken care of. Paul McCorvey, we're gonna reset Janae Langer. I'm gonna have to take a quick break before that 11 o'clock hearing. Thank you, ma'am. Good morning. Are you Paul McCorvey?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
He does.
Mr. McCorvey, in cause number 24 DCCR 1914, you're charged with the state jail felony offense of theft of property from July 3rd of 2024. And how do you plead to that charge?
Guilty, I guess, not guilty, no contest, whatever. Guilty.
Either you did it or you didn't do it. Are you guilty or are you not guilty?
I guess guilty.
There's no I guess. Here's the thing. If you're not guilty, we can set your case for trial. A jury can decide if you're guilty or not. If you're guilty and you want to take this agreement, then you have to plead guilty, but you also have to take responsibility. It's not just going through the motions and saying, I'm pleading guilty, but I didn't really do it. So to the charge of the state jail felony offense of theft of property, how do you plead?
Guilty.
Are you pleading guilty freely and voluntarily?
Yeah.
And are you pleading guilty because you actually did what they charged you with?
Yeah, I guess so. Yeah.
You're about to get your case set for trial.
No, ma'am, I did it. Yeah.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis? Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 4-year deferred probation. There would not be a fine. There would be restitution ordered in the amount of $2,500, and you would be required to follow all of the other rules and conditions of probation. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Mr. McCorvey is not competent?
No, Judge.
And Mr. Nichols, since we have that restitution and
Judge,
it's
I
a
would ask
state
that we go
jail,
forward today.
it was sentencing.
Yes, sir.
So what I'm going to do, Mr. McCorvey, is waive the pre-sentence report, and we'll get a post-sentence report and order. Find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation. Was it 4 years? Sorry, my computer's locked.
Yes, Your Honor.
For a period of 4 years. You're ordered to pay $2,500 in restitution and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you don't have a felony conviction on your record. And if you successfully complete the probation, then the case will actually be dismissed at the end. You'll never have a felony conviction. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, found guilty of the offense, and sent to the state jail prison for up to 2 years. Do you understand? It's very important to me and obviously to the victims that that $2,500 gets paid. So I want you to start making payments on it immediately.
As soon as I possibly can.
And another thing that can happen is if you get that paid off and you do everything you're supposed to on your probation, get your community service done, fees, fines paid, do everything right, it's very likely that you get off probation early.
Community service on this also?
Yes, everyone on probation is required by law that you have community service. And so they'll let you know what that amount is. But the sooner you get everything taken care of, if you do it all correctly from the beginning, you can get off. I sign early terminations all the time. but you have to do it all correctly. Otherwise, you'll do the whole time. Okay? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. All right, good luck to you, sir. You can go back with the bailiff.
Thank you, Your Honor.
Thank you. Maribel Reichel? Do you, Maribel?
Yes, ma'am. Evidently there's some new cases.
There is a case that was filed. It was sent back as a deferred filing for the police to attach the proper media. So I can only hope that's getting done. It was sent a month or so back.
Okay.
It appears it will be a state jail drug case, but the testing's been done. It's just that it was sent back to the agency to collect the property.
Okay, and if you'll check into that, I was just trying to see what was that offense after?
It actually predates this.
It predates this. Okay. Just looking on a state jail felony what her bond is. If there's some question. Is there any other holds, or is it just inability to make the bond? Okay. All right, we'll just do a normal reset then. All right, you can go back with the bailiff. There's another case that's coming, and they're trying to get all that information so that Mr. Lewis can have everything and work it all up together. Okay?
Thank you.
Thank you, Mr. Lewis. Mr. Parker on Xeric trustee.
Rejection.
Good morning. Are you Xeric trustee? Mr. Trustee, in cause number 25 DCCR 0981, you're charged with the second-degree felony offense of aggravated assault with a deadly weapon, and that's from June 19th of 2025. What that means is that if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 20 years in prison. Do you understand? And then in cause number 25 DCCR 0982, you're charged with a first-degree felony offense of aggravated robbery from June 19th of 2025. What that means in that case is that if you go to trial and you're found guilty, the range of punishment would be between 5 years and up to 99 years or life in prison. Do you understand? I have here on the tablet in each of those cases plea bargain rejections that you've signed with Mr. Parker. This shows that the district attorney's office has made offers in each of your cases. Hold on a second. For 15-year terms in prison that would run concurrently, which means together at the same time. You have every right to reject those offers and have your cases set for trial. I just want to make sure you understand what the possible consequences are and what your options are. Do you understand all of that? And do you want to reject those offers and have your cases set for trial? And Mr. Coleman, is there any reason that the state, is it any evidence you're waiting on or any reason to believe that those offers would change?
We don't anticipate any additional evidence, and there is no inclination or any information that we anticipate that would affect the offer that we made in this case.
So, Mr. Trustee, I want to make sure you understand, after today, when your case goes on the trial docket, I will not accept these plea agreements after that. You could change your mind, plead to a different number, or plea open to the court, but it's not going to be to the same offers. Do you understand?
Your Honor, just for the record, last time we reset because there was a video that somebody provided me, and we had them come up here and they provided that to the DA's office or ultimately to the police station. And just so he knows that Mr. Coleman is aware of that video, but it's not changed his offer.
Okay.
Well, I say video as a message.
Okay.
That's correct.
Okay, perfect. So, Mr. Trustee, I'll get your case set for trial. Mr. Parker has been appointed to represent you at this time. He's one of the attorneys who represents a lot of defendants here as a court-appointed attorney. With your permission, I can release him and I can appoint another attorney today who could begin preparation for trial a little quicker. Is that okay with you? Okay, speak up, please. All right, so Mr. Parker, you're released. We will appoint someone today. They should be out to see you very soon to begin preparation for trial. Okay?
I have videos. Can I turn those to the court or?
Yeah, if you will, hand those to the clerk. If you'll make a notation, whoever we appoint, make sure they know we have them and they can come get them from our office. You can go back with the bailiff. Thank you,
Thank you,
Mr. Parker.
Oh, Your Honor, he's was wanting me to ask the court about the bond reduction. I think it's bond said it.
I'm not gonna.
Ask for time.
Yeah, well, nothing's been filed for a bond reduction. You can talk to your new attorney about filing something and I'll set your case for a hearing as soon as that gets filed. Mr. Wilkerson, you have Romeo Johnson. Oh, is that today?
Well, yeah, it should be yesterday.
It should have been. I was wondering. Morning, Mr. Wilkerson.
Good morning, Your Honor.
Good morning, Detective Wilson. Sorry you're having to wait. We'll get to you in just a second. Good morning. Are you Romeo Johnson? And Mr. Johnson, in clause number 24, DCCR 2095 is charged with aggravated robbery, and 25 DCCR 1626 charged with unlawful possession of a firearm by a felon. Mr. Wilkerson, what is the announcement?
We are ready on the aggravated robbery charge, Your Honor. We filed a motion for speedy trial in that case.
Your Honor, the state's ready to proceed on the unlawful possession of a firearm by a felon. It is our belief that the disposition of that case will also be determinative of the other case.
And it's our position that the state can't make the aggravated robbery case, and it's just basically sitting there over this defendant at present.
Well, let's get it set for if there's an offer on the unlawful possession of a firearm by a felon, the state can elect which case they go to trial on. And so if we need to go to trial on that one, let's get it set and we'll go on that one as quickly as possible. If you're ready to reject today, you can. If you need a week or two to make sure you have everything on that one. I know it was indicted not that long ago. So if you need a little bit of time before you do a rejection, we can do that as well.
I think I could actually get that done today.
Okay, I'll hold it while y'all visit about that. That way you can go ahead and get moving. What about Jordan Thomas?
Jordan Thomas.
This is Mr. Hoffpower's case on Jordan Thomas. Good morning, you're Jordan Thomas. And this is 24 DCCR 0487. In that case, Mr. Thomas is charged with sexual assault of a child. And then 24 DCCR 2178, charged with aggravated assault with a deadly weapon. Mr. Wilkerson, what is the announcement?
Judge, in this case, I do need a little bit more time. I have not had an opportunity to meet with my client about the underlying facts. It does look like this has been pending for a while, and I know
it looks like you just,
in October. In October, yes, ma'am.
Okay.
And
All right.
so, in my understanding, the factual bases of the case are different from what my understanding of the situation was when I was retained on the case. But in any event, several trials and whatnot, I just need a little bit more time.
So, Mr. Wilkerson was just hired not that long ago. So I'm going to reset your case one more time to give him some time to get all caught up, get all the discovery, come out and visit with you, and we'll get an announcement at the next court date. All right, you can go back with the bailiff. All right, and so I'll take care of that rejection once you get that done, and then after that, we'll take care of the suppression on Terry Rose. I think that's all I've got, right? Everybody done?
We'll go find some more.
I think we've done our fair share. I'm gonna take a quick break, and then I'll come back in and we'll get all that taken care of.